Hello there, welcome to the show. 2 channels here, now you know. Like and subscribe, it's all we need. Alternature or here to speak. And defense, let's take a peek. Collaborating for your eyes. Sharing content, no surprise. Together we shine brighter than one. Join our journey, it's just begun. Like and subscribe, hit that bell. Enjoy the show and wish us well.
Good morning. As you can see, when they said take a pregnant pause yesterday, I took them seriously. And I did. Hopefully she's not going to wake up now. Anyway, no worries about jury instructions. I hope you all can hear me because I can't get the mic closer. I did, Becca. I did. Yep. Yes, it's a super baby. Anyway, don't worry. I have a pause. We're going to see all those jury instructions that y'all are waiting for. Yes. Zach Daddy, where you at, man? That child support. Also, stop it. Is my mic okay? Because obviously I'm a little bit further back from my chair than normal. So, oh, he's going to pay. He's going to pay me in gay frogs. Yes. Okay. Thanks, Gabby. Alrighty. Sorry, I've been rushing towards the end of this. I got my hands full, as you can see. So, yeah, there's that. So I have an announcement to make. Yes, I Russian. Are you Russian too? Hello, Tanya. Good evening. So, I have had some things come to light, and I have had obviously some changes coming my way. So I know this is going to catch everybody out of left field, including Jody. But this will be my last dual stream today. I have to step back. I have to figure out some things, and I have to, I need to reevaluate how I'm going to do things going forward, because I have this little precious angel and some other things I need to take care of. So I will be back. I will be doing my normal schedule, which was only 3 days a week. No, Beck, I'm fine. But I can't do this schedule anymore. And so I don't know if Jody can hear me or not. But so yeah, I have to do it. So I'm not leaving and just stepping back. So that's it. That's all I got. We're going to listen to jury instructions, and do this trial and get through it, and then go from there. So let's rock and roll.
Jury instructions. I've done this more times than I can count over the last 20, 25 years of my life. Sometimes I hear these instructions in my
He
sleep.
sounds really
I couldn't
soft.
sit down and write them all out for you from scratch. I don't believe it. You're going to have instructions to take back. So you sit there and listen. You'll have instructions to take back to read during your deliberation. Okay? All right, members of the jury, you have heard all the testimony and received the evidence in the course of this trial. You took your places in the courtroom. You made an oath to follow and apply the instructions of the court regarding the law. The court will now instruct you as to the rules of law which you will use to apply to the evidence in deliberating your verdict. You are not to single out one instruction alone as stating the law, but you must consider these instructions as a whole. Neither are you to be concerned with the wisdom of any rule of law. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your sworn duty to base a verdict upon any other view of the law than that given in these instructions by the court. If in stating the law to you I repeat any rule, direction, or idea, or if I state the same in varying ways, no emphasis is intended, and you must not draw. Let's hold down the talk in the audience. If in stating the law to you I repeat any rule, direction, or idea, or if I state the same in varying ways, no emphasis is intended, and you must not draw any inference therefrom. The order in which these instructions are given has no significance as to their relative importance. It is your function to determine the facts in this case and to consider and weigh the evidence for that purpose. You are to apply the law to the facts and in this way decide the case. The evidence which you are to consider consists of the testimony and statements of the witnesses, any stipulations made by the attorneys, and any exhibits admitted into evidence. You are also permitted to draw such reasonable inferences from the evidence as seem justified in the light of your own experience. It is your prerogative to determine what weight and what credibility will be assigned the testimony and supporting evidence of each witness in this case. You are required and expected to use your good common sense and sound honest judgment in considering and weighing the testimony of each witness who has testified. You should not be influenced by bias, sympathy, or prejudice. Your verdict should be based on the evidence and not upon speculation, guesswork, or conjecture. The production of evidence in court is governed by rules of law. From time to time during the trial, it has been my duty as judge to rule on the admissibility of evidence. You must not concern yourselves with the reasons for the court's rulings, since they are controlled and governed by rules of law. You should not infer from any ruling by the court on these motions or objections to the evidence that the court or the judge has any opinion on the merits favoring one side or the other. You should not speculate as to possible answers to questions which the court did not require to be answered. Further, you should not draw any inference from the content of these questions. You are to disregard all evidence which was excluded by the court from consideration during the course of the trial. The law presumes every person charged with the commission of a crime to be innocent. This presumption places upon the state of Mississippi the burden of proving the defendant guilty of every material element of the crime with which she is charged. Before you can return a verdict of guilty, the state must prove that the defendant is guilty beyond a reasonable doubt. The defendant is not required to prove her innocence. The verdict of the jury must represent the considered judgment of each juror. In order to return a verdict, it will be necessary that each juror agree thereto. In other words, all 12 jurors must agree on any verdict in this case. It is your duty as jurors to consult with one another and to deliberate in view of reaching an agreement if you can do so without violence to your individual judgment. Each of you must decide for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberation, do not hesitate to re-examine your own views and change your opinion if convinced that it is erroneous. But do not surrender your honest convictions as to the weight or effect of evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. The court instructs the jury that the defendant has a constitutional right not to testify at trial. You should not draw any inference from the defendant's failure to testify. The defendant's failure to testify should not in any way be considered by you during the course of your deliberations. The court instructs the jury that you have heard testimony from expert witnesses. Persons who by education and experience have become an expert in some field may state their opinion on matters in that field and may also state their reasons for the opinion. Expert opinion testimony should be judged just like any other testimony. You may accept it or reject it. and you may give it as much weight as you think it deserves, considering the witness's education and experience, the reasons given for the opinion, and all other evidence in this case. You are instructed that the indictment creates no inference of guilt, and the fact that the defendant was indicted shall not be considered as evidence against him by the jury, and no inference of guilt can be drawn therefrom. You must not base your verdict solely on the number of witnesses for either party. The defendant, Carly Madison Gregg, has been charged by indictment in count 1 with the crime of first-degree murder, in count 2 with the crime of attempted murder, and in count 3 with the crime of tampering with physical evidence. Count 1. The court instructs the jury that the defendant, Carly Madison Gregg, has been charged in the indictment with the crime of first-degree murder. You find from the evidence in this case beyond a reasonable doubt that on about the 19th day of March 2024 in Rankin County, Mississippi, the defendant, Carly Madison Gregg, did willfully, feloniously, and without authority of law kill and murder Ashley Smiley, a human being. With deliberate design to effect the death of Ashley Smiley, then you shall find the defendant guilty as charged in count 1. If the state has failed to prove any one or more of the above listed elements beyond a reasonable doubt, then you shall find the defendant not guilty as charged in count 1 of the indictment. The court instructs the jury that the defendant, Carly Madison Gregg, has been charged in the indictment with the crime of attempted murder. If you find from the evidence in this case beyond a reasonable doubt that on about the 19th day of March 2024 in Rankin County, Mississippi, the defendant, Carly Madison Gregg, did willfully, unlawfully, and feloniously attempt to kill Heath Smiley, a human being, but failed to complete the act, then you shall find the defendant guilty as charged in count 2. If the state has failed to prove any one or more of the above listed elements beyond a reasonable doubt, then you shall find the defendant not guilty as charged in count 2 of the indictment. Count 3, the court instructs the jury that the defendant, Carly Madison Gregg, has been charged in the indictment with the crime of tampering with physical evidence. If you find from the evidence in this case beyond a reasonable doubt that on about the 19th day of March 2024 in Rankin County, Mississippi, the defendant, Carly Madison Gregg, did willfully, unlawfully, and feloniously intentionally destroy, mutilate, conceal, remove, or alter physical evidence with intent to impair its use, verity, or availability in the pending criminal investigation or prospective official proceeding, then you shall find the defendant guilty as charged in count 3. If the state has failed to prove any one or more of the above listed elements beyond a reasonable doubt, then you shall find the defendant not guilty as charged in count 3 of the indictment. The court instructs the jury that there is a presumption that an accused is sane, and therefore the burden is initially on the accused to introduce evidence which creates a reasonable doubt as to her sanity at the time of the act. However, once the defendant has created a reasonable doubt as to the defendant's sanity, it is the burden of the state to present sufficient evidence to prove the defendant's sanity beyond a reasonable doubt. The court instructs the jury that the following is the definition of insanity in Mississippi. Insanity exists when at the time of committing the act, the accused was laboring under such defect of reason from disease of mind as 1, to not know the nature and quality of the act she was doing, or 2, if she did know the nature and quality of the act, she did not know that what she was doing was wrong. The court instructs the jury that if you find that the state has proved beyond a reasonable doubt all the essential elements of count 1, first-degree murder, count 2, attempted murder, and count 3, tampering with physical evidence, then you must find the defendant guilty of count 1, first-degree murder, count 2, attempted murder, and count 3, tampering with physical evidence, unless the state of Mississippi has failed to prove beyond a reasonable doubt that the defendant was sane at the time the defendant committed the crimes of count 1, first-degree murder, count 2, attempted murder, and count 3, tampering with physical evidence. In order to prove the defendant sane at the commission of the crimes of count 1, first-degree murder, count 2, attempted murder, and count 3, tampering with physical evidence, the state must prove beyond a reasonable doubt that at the time of the commission of the crimes of count 1, first-degree murder, count 2.
All right, that's on their end. Just letting you know.
Attempted murder, and count 3, tampering with physical evidence. The defendant had the mental capacity to realize and appreciate the nature and quality of her acts and to distinguish between right and wrong with reference to the act she committed. If after considering all of the evidence in this case, you find that the state has failed to prove beyond a reasonable doubt that the defendant was sane at the time of the commission of the crimes in count 1, first-degree murder, count 2, attempted murder, and count 3, tampering with physical evidence, then your verdict must be not guilty by reason of insanity. The court instructs the jury that if you find that the defendant, when sober, is capable of distinguishing between right and wrong, and the defendant voluntarily deprives herself of the ability to distinguish between right and wrong by reason of becoming intoxicated and commits an offense while in that condition, she is criminally responsible for such acts. The court instructs the jury that when all 12 of you reach and agree upon a verdict as to the indictment, you shall return the verdict to the court in one of the following forms.
Great. We can't even hear him.
Count one, as charged in the indictment, close quotes. Tampering with evidence as charged in the indictment, and state your verdict as follows. Quote, with the jury, if either side needs them, you can come get them. If you use them, return them in the same order you pick them up in. Closing arguments on behalf of the state.
I got to find a better feed. Really? Sorry, it went to Judge Wolf. George must be controlling it. Hopefully this one's better. Oopsies.
One shred of evidence in this case stood before you on
Statement or remark has no basis in the evidence, then you should disregard that argument, statement, or remark. Jury instructions will be on the bench in front of the court. If either side needs them, you can come get them. If you use them, return them in the same order you pick them up in. Closing arguments on behalf of the state. Mr. Shipley, you'll keep time.
May it please the court. Good morning, ladies and gentlemen. As Ms. Todd stood before you on Monday in her opening statement and told you this is not a case about who did it. And in fact, all of the evidence that you've seen tells you exactly that. It's not a case about who did it. You haven't seen one shred of evidence in this case that what happened on March 19th, 2024 was caused by anyone other than Carly Madison Gregg. The defense also told you during opening statements on Monday that the state wants you to leave your common sense at the door, that they want you to tie it up in a bucket and leave it at the door. Ladies and gentlemen, all we want you to do in this case is use your common sense. And in fact, that's what Judge Arthur just instructed you to do in the very first jury instruction. And I want to talk about a few of these jury instructions with you real quick. But in jury instruction number 1, which you'll have back in the room with you, on the second page, he instructs you, you're required and expected to use your good common sense and sound, honest judgment in considering and weighing the testimony of each witness who has testified. You should not be influenced by bias, sympathy, or prejudice. Your verdict should be based on the evidence and not upon speculation, guesswork, or conjecture. Ladies and gentlemen, on behalf of the state, all we want you to do is to go back there and use your good common sense and your sound, honest judgment. And again, I don't believe that you've heard one shred of evidence throughout this entire week that the person who shot Ashley Smiley was in fact Carly Madison Gregg. The person who shot and attempted to kill Heath Smiley was Carly Madison Gregg. And the person who took down the camera from the kitchen and hid it in the refrigerator behind some water bottles was Carly Madison Gregg. Now, Judge Arthur also read you the elements of the crimes. And again, you'll have this information back there with you in the jury instructions. It's jury instruction number 8. And I kind of want to go down because as a simple person myself, I like to kind of have a roadmap as to where I'm going. So I like to be able to look at things and see them on paper. And that's exactly what these jury instructions provide you, kind of a roadmap to help guide you in your deliberations. So I want to talk about count 1, which is the first degree murder. And there's 3 elements here that it has listed. And the very first one says that on about the 19th day of March, 2024 in Rankin County, Mississippi. That's the first thing you have to find. Ladies and gentlemen, all the testimony has been that this happened on March 19th, 2024. You heard from Deputy Hunter Lewis, who was the first deputy who arrived on the scene there, that he was called out that day, that he received a call from dispatch to respond to 214 Ashton Way, which is in the Farmington Station subdivision off of Old Fannin Road. And you heard Mr. Kevin Collins, the 911 dispatcher, who told you that the call out came on that day at that time about 5 o'clock in the afternoon. And you heard them tell you that obviously Farmington Station is located in Rankin County, Mississippi. So there's no question as to that first part of the element there. As to number 2, that the defendant Carly Madison Gregg did willfully, feloniously, and without authority of law kill and murder Ashley Smiley, a human being. Well, ladies and gentlemen, you heard from Mr. Cliff Dunlap, the deputy coroner, who told you that the manner and cause of death in this case was found to be 3 gunshot wounds to the head, and that it was found to be homicide, and that the victim was indeed identified as Miss Ashley Smiley. The last part there is that she did it with deliberate design to affect the death of Ashley Smiley, the victim. Ladies and gentlemen, I would submit to you that in the state of Mississippi, when it talks about deliberate design, that it's simply talking about an intent to kill the victim, Ashley Smiley, that she did this with an intent to kill. And I would further submit to you that the use of a deadly weapon is an intent to kill. Whenever you aim a deadly weapon, a pistol, a .357 revolver at someone's head and you shoot 3 times, that's certainly an intent to kill. Now, again, it's not a case about who did it. And I'll show you some of the video here in just a second. But let's think about what happened that day. So you remember from the video, you saw from the garage, you heard several witnesses talk about it, that earlier that day, Mr. Bennett Germany and another friend, Sarah Catherine Rayleigh, who the defense put on the stand yesterday, you heard from them, and they said they devised this plan to go talk to Ashley, to go talk to Carly's mom, because they were worried about Carly. They were good friends. They were worried about Carly, and they were worried about her drug use, her use of burner phones. And I just want to be clear, ladies, this is not a case about marijuana and whether or not she was smoking marijuana. This is a case about whether or not she was intoxicated, voluntary intoxicated. You heard me talk to Dr. Clark about that she would, one of these times that she says she has one of these events where she supposedly zoned out. That in fact, what happened was that she went and smoked marijuana. It could have been any drug, but it was just marijuana. And she zoned out, and she had this event where supposedly she says that she, fell out on the floor and whatever happened. And she did that after her mom and Heath left one day and went to the grocery store. But I just want to be clear, it's not a case about marijuana. It's simply a case about, her actions. And so Bennett and Sarah Catherine, they devised this plan. They're going to tell Miss Smiley. Well, obviously, you heard testimony that one of the things that Miss Smiley was worried about was her daughter, Carly, the love of her life. You heard that she had another daughter who died at a very young age from some type of genetic disorder that she had. So you got Carly here. She's the love of Ashley's life. Obviously, she's disappointed, probably a little bit sad, probably worried for her daughter. And the last thing that she wants her to do, according to the defense, is turn into her dad, right? Her biological dad, who you've heard about, who obviously liked to use a lot of drugs, abuse a lot of drugs. So at some point, she confronts Carly. She searches her backpack, whether in the car on the ride home or at the school. And then you see them get home, and you heard Dr. Pickett talk about it yesterday, that the situation seemed a little bit tense, right? That they get out of the car in their garage. You don't hear, they're not talking to each other. And they go in, you see Ashley put her coat and her phone down on the bar there in the kitchen, and she proceeds directly to the side of the house where Carly's room is located, presumably to start searching through Carly's room, right? And so you see Carly kind of walk back and forth. You see her walk there to the living room area and kind of listen to see what her mom's doing. At some point, she eventually takes the dogs out, right? I don't know what happened while she was outside, ladies and gentlemen, but at some point, whenever she was outside, she made up her mind, if not long before. We'll talk about that in a second, her conversations with her friend from MSMS, Thad, that you heard from. But at some point outside, she makes up her mind exactly what she's going to do. And she comes back in from taking out the dogs. She walks there to that living room area, kind of listens to see if her mom's still in her room. And then without hesitation, she walks, as Dr. Pickett said, to the side of the house, her mom and Heath's bedroom, where this pistol is located. She knows it's located there. Now, they want you to believe that from the time she brought the dogs back in or took the dogs out, that she blacked out at that point. You heard me ask Dr. Clark. Well, from the time she took out the dogs to the time she was arrested by Deputy Shack, who you also heard from, that she was blacked out in that period. Well, that's a real convenient time to be blacked out, right? And so she brings the dogs back in, and she goes directly to her mom's room and Heath's room, and she retrieves this pistol. And you see her walk back across the screen. Well, when she gets there, she looks around the corner into the kitchen to make sure that her mom hasn't come out of her room, knowing exactly what she's doing. Cool, calm, calculated, and callous. She walks directly, she proceeds to her room, and a couple seconds later, you hear the shots. Boom, boom. You hear two shots within 3 seconds of each other. You've seen the pictures. You heard Dr. Pickett testify yesterday. Two well-placed shots right to the side of Miss Smiley's head, a relatively small target. And then a couple seconds later, boom, you hear a third shot right under the chin. And we believe it's right under the chin is the third shot. We know it's right under the chin. We believe it's the third shot. You heard Deputy Investigator Burnell talk about the stippling, the powder burn around the shot, right? And he tells you that based off his training and experience, that shot had to be within 36 inches, because that's when you see stippling, the powder that comes out that's still ignited, that doesn't have time to burn, and it burns right here on Miss Smiley's face. And then what does she do? Immediately, you'll see on the video that happens at 4:14 p.m. Immediately, she comes back in. She gets on her mom's phone. She has the wherewithal to enter her mom's code onto her phone and to text someone specific. And that someone specific was her stepdad, Heath Smiley. And you'll see that text message was sent within the same minute, 4:14, that she shot and killed her mom. And what did she say to him? Something to the effect of, "When are you going to be home, honey?" And it's perfect grammar. The comma's in the right place, right before honey, right? She knows exactly what she's doing. She comes in there. She knows exactly where the camera is. She comes. She's got the gun hidden behind her. She slides down into the chair, and you hear her put it down on the bar stool. You can hear it whenever you get back to the jury room, you'll be able to hear that. She puts it down. And you hear Dr. Pickett talk about, she's got the wherewithal to know exactly where the dogs are. The dog walks behind her. You'll see it. He walks behind her, and she knows to, oh, let me make sure he doesn't knock the gun off. Right? At some point, she begins text messaging her friend. She shoots her mom at 4:14. Then she invites her friend from school, who you heard from, Brooke. She invites Brooke over. You'll see the messages between her and Brooke. They're in evidence. And you'll see where Brooke texts her at 4:58, basically 40 minutes later, 45 minutes later, and says, I'm here. Brooke had no clue what she was about to walk into. Carly meets her at the door, says something to the effect of, have you ever seen or are you squeamish of dead bodies? Well, Brooke says, I don't know. I've never seen a dead body. Not thinking that there's a dead body currently in the house, right? Carly's walking around with the gun. Carly leads her back to the room and shows her dead mom, who's got her arms crossed over, who's been posed, right? She's posed her mom at this point. She's put her arms across her. She's put a red towel over her face. Again, cool, calm, and calculated. She knew exactly what she was doing. She knew exactly who to reach out to during this time. She's reaching out to all of her friends. You heard from multiple friends that she reached out to. You heard from her friend Thad, who she was texting, and actually before they text, she calls him on FaceTime. And what does she tell him? Well, she tells him, and excuse my language, I fucked up, right? Well, how do you know you messed up if you don't know what you did? She knew what she did. She knew the difference between right and wrong. So she obviously tells Thad, but she can't tell him what she did. She knows she can't tell him over the phone. Well, then, being a good friend and being worried, Thad begins to text her after they get off the phone. And they're messaging. Well, of course, in the meantime, she's walking back and forth in and out of her room where her mom's located. She's walking back and forth. She's sending messages to multiple other friends. And Thad is messaging her, but he can't get a response. And he says, I'm worried about you. If I don't hear from you, I'm going to call 911. And she says, you can't do that. Why? Why can't you call 911? Because she knows what she did was wrong. And she doesn't want 911 over there because she's about to try to kill Heath. And she doesn't want 911 over there because it's going to ruin her plan. Right? Knowing the difference between right and wrong. And you heard me, I very specifically asked Dr. Clark, you render the opinion that she could not appreciate the difference between right and wrong. Right? Well, you heard Dr. Pickett and Dr. Gugliano testify yesterday. That's not the standard in Mississippi. In fact, there's an instruction in here that defines, it's jury instruction number 10, that defines exactly what insanity is. And it goes on down there, and it says that the accused was laboring under such defective reasoning from disease of mind as to not know the nature and quality of the act she was doing, or 2, if she did know the nature and quality of the act she was doing, she did not know what she was doing was wrong. It's not appreciate. The standard in Mississippi is not that you appreciate the difference between right and wrong. She knew what she was doing was wrong. Look at all of her actions. Sneaking around the house, calling over the friends, knowing not to tell the friends over the phone what she did. SK that they called in yesterday, her friend. What does she say? Dr. Pickett talked about it. Well, she says, I'll tell you tomorrow if I see you. Well, why would I not see you tomorrow? Well, because I'm going to be in jail probably. Right? She knew what she did was wrong. She tells her friend, Brooke, whenever Brooke comes over, she says, I put 3 in my mom, and I've got 3 more in here for Heath whenever he gets home. Right? I'm going to take care of him. Three more what? Three more bullets in the gun. She texted her friend Bennett, tried to call him, did call him, text him, and he tells her, of course, again, he's a good friend too. He's worried about her. Same one that told her mom what had been going on, that he was worried about her. Trying to do the right thing. He tells her, don't hurt yourself or anyone else. Don't harm yourself or anyone else. What does she say? Too late. Again, knowing the difference between right and wrong. You saw the video from Deputy Shack, and they want you to believe that he did something wrong because he muted his body cam or whatever he did. He told you that whenever he got Carly out of the back of his car and the other deputy started performing the GSR test on Carly's hands, which you saw them doing there, being as nice as all get out to her, right? Baby, are you okay? You heard him say that his involvement in the case was over. He never went in the house. He didn't transport her to jail or anywhere else. They want you to believe that him muting the body cam was him doing something wrong. He told you that his involvement was done and over at that time. Now, I want to play just a short clip of the video for you before my time's up. Thank you, Aaron. Ladies and gentlemen, there's no doubt that Carly Madison Gregg is the one who killed her mom, Ashley Smiley. There's no doubt that she attempted to kill P. Smiley when she aimed the gun right at his head and shot and hit him in the shoulder. And there's no doubt that she's the one who hid the camera, thus tampering with evidence in the refrigerator. And we would ask you that you go back there and you find her guilty of all three, because she was not insane at the time that this happened. She knew exactly what she was doing, and she knew the difference between right and wrong.
Minute and a half on the back end, so it'll be 18 and a half minutes. All right, closing by the defense.
May we begin?
Yes, sir.
Good morning. I know it's been a long week for all of you guys, and I know you're tired of coming here every day. But I want to take a minute and talk about why the state has the burden of proof that they have, the highest burden of proof that our law allows, which is beyond a reasonable doubt. A lot of people think that having that high of a burden is there because it's supposed to protect the defendants in criminal cases. But in fact, I think it protects the jurors just the same, if not more, than it does the defendant, because making the state prove every element of their case beyond a reasonable doubt is what is going to keep each of you from waking up in the middle of the night. The decisions that you make today will not just affect Carly Gregg, it will affect her entire family. And it's a heavy burden to carry. So I want to take a few minutes and talk about the truth. The truth is rarely pure and never simple. That's what Oscar Wilde said. Let's talk about what is undisputed in this case. It is undisputed that Carly loved her mom. You never heard the testimony of one person in this case who said otherwise. It's undisputed that Carly had no history of violence prior to March 19th. Nothing you heard. There is no evidence that tells you otherwise. It's undisputed that Carly Gregg loved her stepdad. In fact, he was the only dad she really ever had. No one told you otherwise. It's undisputed that Carly Gregg believed her father had a mental illness, bipolar disorder, and schizophrenia. Carly was afraid of her dad. She knew he was an unsuccessful man. She knew he was abusive. She didn't like being around him. She didn't want to be like him. It's also undisputed that that's something Carly worried about all the time, because that's something her mom worried about all the time. Her mom frequently worried that Carly was going to end up with the same mental illnesses that her dad had, because they're hereditary. It is undisputed that Carly had been experiencing serious mental health issues for quite some time prior to the events of March 19th. She had bulimia for 2 years. She had intrusive thoughts. She had racing thoughts. She had engaged in self-harm behaviors. Carly had anxiety. She had been diagnosed with a major depressive disorder, and she had developed trouble sleeping for months prior to March 19th. Moreover, we have her journal entry from April 7th of 2023 in which she writes down, "Do I have schizophrenia?" We have Carly's other journal entries prior to March 19th, including her journal entry on March 12th, which you'll have back there in there with you, and I implore you to read, in which Carly writes down and says, "Am I having a psychotic break?" Talking about the voices in her head. We heard the testimony of SK, and that testimony came out on cross-examination, not with me on direct, but with the prosecutor on cross, that yes, Carly did in fact tell somebody prior to March 19th that she'd been hearing voices in her head. And who did she tell? The person she was most likely to tell, her very best friend, who told us that they told each other everything. Now, it is also undisputed that Carly's mental health issues worsened by December of 2023 to the point that her parents sought medical intervention and put her in counseling and got her on an antidepressant. And I want to take a minute and break that decision down because we've spent a lot of time in this case talking about Carly and her mom and how much they loved each other. But I want to break down the decision a mom is making to put her child on an antidepressant at that point. What did we know about Ashley Smiley? That she was an incredibly loving mother. Her world revolved around Carly. What Michael just told you was true. Carly was the love of her mother's life. We also know that Carly's mom was overprotective, and understandably so, because she had lost a child. Carly was the only child she had left. Do you honestly believe that loving, overprotective mother would make a decision to put her child on an antidepressant medication when she herself had had horrible side effects when placed on Prozac? She'd become suicidal. Do you think that mother would have taken any risk with her child, the only child she had left, knowing how serious those risks were, when she decided to put her 14-year-old on an antidepressant medication? No, of course she wouldn't. That tells you everything you need to know about the serious issues Carly was having, whether her parents wanted to admit it, whether Carly wanted to admit it or not. You can't tell me Ashley Smiley, as loving and protective as she was, would have taken that risk, Carly, if it wasn't required. Now, knowing all this, it's also undisputed by Rebecca Kirk, the only medical professional who spent more than a day with Carly that you heard from in this case, who had treated Carly from January of 2024 to March of 2024, a 3-month period of time, that Carly was a sweet, gifted child with no history of violence. Ms. Kirk also called the taking the knife to school incident much ado about nothing. She told us that it was evident that Carly loved her mom, wanted to please her mom, and was worried about stressing her mom out to the point that Carly walked on eggshells, trying not to upset her mom. She told us a story about how at one point Carly saw her mom having to grade a bunch of tests, being stressed out, and Carly wanted to help. So she asked her mom if she could help her grade the test. And when Ashley snapped back, which is something parents sometimes do when they're stressed out and a child catches you at the wrong moment, that hurt Carly's feelings so much, that was the only thing that Rebecca Kirk could pull out of her when she was trying to get Carly to open up about traumatic experiences she had had. Just having a mom snap at you was traumatic to Carly. How could Carly tell her mom she was experiencing the same mental health issues that her dad had? How could any 14-year-old? It's also undisputed from Ms. Kirk herself that she knew there was more going on with Carly than Carly was disclosing. And she worked very hard at that last session trying to pull it out of Carly, to the point that she thought, maybe I should refer them to somebody else because there's more here than I can get to. We've heard the testimony of Carly's stepfather, who has no reason to defend this child. It's not his biological child. He was very much in love with his wife. They were still in the honeymoon phase. You heard him on that 911 call. That was a man in shock, in grief, and in pain. You heard his testimony about feeling intimidated regarding his testimony in this case. But despite all of that, he has continued to tell the truth consistently from March 19th until his testimony in this courtroom today, and he continues to stand by Carly to this day and support her. And he said, yeah, I've noticed that Carly was experiencing memory lapses in the fall of 2023. It was bizarre. I noticed that Carly was losing track of time It was bizarre. They knew Carly wasn't able to sleep. They were worried about how much melatonin she was taking to try to sleep at night. We heard from Dr. Pickett how that all correlates with bipolar disorder. It is undisputed from the testimony of the minors who testified in this courtroom today, this week, that Carly had only started smoking marijuana in February. It is also undisputed by the testimony in this case and the records we put in evidence from Vital Corps, which you'll have back there with you, and I hope you'll look at, that it was only after Carly was finally put on Abilify, an antipsychotic medication, that the voices stopped and her mental health issues decreased. The crying spells, the depression, the low lows. Only after the antipsychotic medication. And why? Well, we heard from the medical professionals why. In the words of Dr. Clark, when you have a child experiencing psychotic issues, you have to stabilize their mood before an antidepressant can be effective. And if you don't stabilize their mood, then the antidepressant can do more harm than good. And that's exactly what happened to Carly Gregg on March 19th. We heard the video from the garage cam of Heath Smiley coming home on March 19th. We heard those feral screams that Carly made the whole time. And we heard the testimony of Mr. Smiley that he was so convinced by the state of terror Carly was in that after she left that house and he was wounded and bleeding, he walked around the house with the handgun looking for the intruder that he believed was there based on the state of terror Carly was in. We heard the screams. You can't fake that. You can't make that terror up. Carly has consistently reported to everyone that the last thing she remembered on March 19th was taking the dogs out, and the next thing she remembered was crawling through a sewer filled with water. And I personally believe that it was the cold water that brought Carly back out of it and back to herself, the shock of it. The state would have you believe that Carly intended to kill her mom on March 19th when Carly didn't even know during the evaluations that her friends had sought to intervene because they believed that what they saw from Carly was due to marijuana use that started in February rather than symptoms of a mental illness that they could not know about. But that story just doesn't track. Because for the genius kid that Carly has been repeatedly described as, don't you think she would have known if she intended to do what she did on March 19th, where the camera was in the kitchen, and that she ought to take it down before it films her doing everything she did? Because I didn't make a 30 on my ACT, but I would have known to do that. That doesn't sound like the actions of a smart kid who was intending to do anything. If Carly intended to kill her mom because her mom found out she was smoking pot, then why wouldn't she have left the house after she killed her mom? Why not run then? Why call all of her good friends asking for help, terrified, crying, saying she couldn't tell them what happened? Why text her stepdad anything? Why wait in the house? And what did her stepdad have to do with anything? He didn't know about the marijuana usage. He didn't have any skin in that game. It doesn't make sense. And the state can't tell you why she did any of those things. But they have to prove it to you beyond a reasonable doubt. Now, no one, not her stepdad, not her counselors, not Dr. Clark, who was teaching psychiatry at Harvard while Dr. Pickett was still in medical school, believed that Carly was a sociopath or a psychopath. Even Dr. Pickett said that was going too far. The state put on the testimony of BW, who is the only person who told us anything about Carly making a statement about shooting her mom, and she had 3 more for her stepdad. I didn't hear that statement from the law enforcement officers that interviewed her. I heard it from the prosecutor. But I also heard from the prosecutor that BW was a little bit of an unreliable witness because she answered the first question of, where did Carly get marijuana from? I don't know. To have to answer immediately with the follow-up question, well, isn't it true that you bought it and gave it to her? Yeah, that's true. So that tells us right there, we've got a little bit of an unreliable witness. Now, we also have Dr. Pickett, who gave us his opinion. But Dr. Pickett admitted that he had no experience whatsoever in the field of child and adolescent psychiatry. He had never evaluated a child before Carly. He had never testified in a criminal case before, and he had never qualified as an expert before in anything, in any criminal case before this one. So I have a hard time accepting Dr. Pickett's opinion that, especially when he is discounting the diagnosis of a doctor who diagnosed Carly's father with bipolar disorder, and the reason that Dr. Pickett told us that he discounted this other doctor's diagnosis was because that doctor had only seen Kevin Gregg 3 times. Well, Dr. Pickett saw him 0 times, but yet he's able to undiagnose him and re-diagnose him. I mean, if Dr. Pickett can diagnose or undiagnose someone without ever seeing them, he's going to have a hell of a career. And even though Dr. Pickett denied having a preconceived bias going into this case, I couldn't help but realize he had memorized all the medication that Kevin Gregg was on that he believed contributed to Kevin Gregg just being a drug addict. But he somehow missed the 3 antipsychotic medications that Kevin Gregg had been on. That Mr. Gregg had been prescribed for his bipolar disorder and possibly schizophrenia. You know what? Those facts didn't fit his story, so no need to include them. And I actually couldn't stop thinking about that. Why was it that he memorized the medications he believed were easy for people to abuse and become addicted to, but just couldn't remember it all? The 3 antipsychotic medications that Mr. Gregg was on at the same time. That stood out to me, who's not a doctor and who doesn't have training in these fields. I had to go Google those drugs to learn they were antipsychotics. And then I realized when I was looking at Dr. Pickett's CV, which we also put into evidence, and I hope you look at, that he served as a Hinds County Sheriff's deputy for 3 years prior to going to medical school. And it made sense. Then his diagnosis made sense to me, because when you're a hammer, everything looks like a nail. I hope that seeing all the people who knew and loved Carly the best prior to March 19th, her friends, her maternal grandparents, her stepfather, her counselor, I hope seeing that they still love and support Carly Gregg after March 19th tells you everything you need to know about the incident that occurred on March 19th, that wasn't Carly. Because if it was, why would the parents of those friends still let their daughter call Carly? Why would they be here testifying for her? And let's talk about this genius kid. The easiest story she could have told would have been, I shot my mom and stepdad because my stepdad had been molesting me for years. My mom knew about it and said nothing. And people would have bought it all day long. That's a convenient lie. And it would have served her all day long at the expense of her mom and her stepdad. That's the easier story to tell. But that's not what Carly said. Carly told the hard truth about her mental health issues. A truth that these are rare and it's happening, but that this happens often when you put kids on the wrong medication, when they already have these underlying significant mental health disorders and they get treated with the wrong medication. This is what can happen. I hope none of us are ever judged by the worst moments of our life. but rather by our lives as a whole. And I think when you step back and you look at the facts of this case as a whole, okay. And when you look at the facts of this case as a whole and the picture of who Carly Gregg is as a person on a whole, you will see that this was not a bad kid. This was not a kid who was enraged. This was not a kid who had hatred in her heart for her mother or her stepfather. In fact, the exact opposite. This was a kid who was experiencing significant mental health issues, the same mental health issues that ran in her family and that we know are hereditary. This is the kid who was compliant with the medication she was put on. However, that medication, without anyone being able to tell beforehand, caused her symptoms to worsen. And while she was having a state of psychosis in an episode of acute stress on March 19th, she lost herself in what was the perfect storm. I am asking you, for those reasons, to please find Carly Gregg not guilty by reason of insanity and finally quell this storm for Carly and her family. No one will understand this case and no one has heard this case the way that you have. And passing judgment on another person is a heavy burden to bear. And I'm sorry that it falls on you. But please consider what is at stake in this case for this child and this family before you rush to judgment and render your verdict. Look at those documents. Consider the testimony. Search your heart for what you know about this child from the picture painted by her of all the people that knew her best. And you tell me, what was the intent? You tell me why someone who intended and had planned to murder someone wouldn't have taken the camera she knew was in the kitchen and was easy to see down before she did anything, especially when she was a genius. I mean, that's not the actions of a diabolical, evil genius, leaving camera footage up for everyone to see, crawling through a sewer instead of just running away, calling friends for help, friends who could later testify about what happened. Again, I ask you to search your hearts and remember the undisputed truths in this case. Thank you.
Mr. Camp, 17 minutes. Thank you. Won't start the clock until you have everything set up and you're ready then.
May it please the court?
Yes.
Okay, we've been doing this since Monday, so I know y'all are probably as tired as I am. This was always going to be a very difficult case, and it's going to be difficult because the issues that we're dealing with is difficult because we're in part of a realm of the law and everything where you've been hearing a case all week and the defendant has basically said she's guilty. And so there's not an issue of guilt in this case. As we said from the get-go, this is not a who did it case. This is why it happened. Okay, what's going on? That's what you have to make the determinations is what's going on in Carly's mind as all this stuff is happening. And that's the difficult part, because you don't get to just look at the video and say, she did it, because that's, most cases, that's what you're doing. And it's an easy decision, because you're looking at it and you simply see who did what, how they did it, and that's it. Now, in this case, because we're dealing with her mental state, we're having to get inside her mind and understand what's going on and how that's all working. And that's what this case has always been about from the get-go. It's never been about who did it. One of the things that I wanted to talk with you just a little bit about is you had, in this case, you had 3 psychiatrists, or excuse me, 1 psychologist, 2 psychiatrists. And both of the psychiatrists were forensic psychiatrists. The psychologist was a forensic psychologist. And you had the 2 psychiatrists gave very different opinions, very different opinions. And some of the things that I wanted to point out on that is you have one of the doctors, which is Dr. Pickett. It was his first time ever being qualified as an expert, first time testifying. He just got certified a year ago. And then you have an opinion of somebody who has even a higher degree, and that's Dr. Clark. And Dr. Clark is board certified in pediatric and adolescent psychiatry, which means he deals with kids. He deals with teenagers. He knows the nuances of how that works. If you listen to Dr. Pickett, and Dr. Pickett was 100% correct on this. He can do evaluations on everybody. But the problem is he doesn't know the nuances of the kids and the adolescents. And we're dealing with an adolescent. Carly was 14 when this happened. She turned 15 in jail. As all of y'all know, things are changing in people's bodies at those ages. They're growing, they're becoming adults. You have a lot of different things going on. All those things have to be taken into consideration when you're coming up with the decisions, or when you're coming up with how to do an evaluation on a person. And that's why you need that specialized knowledge, is to know what's going on in teenagers. Dr. Clark gave you a very precise reason of how all this happened, why it happened. And he said it was a difficult case to look at. Dr. Pickett, he basically wanted to just pick Dr. Clark's case or diagnosis part and say, couldn't happen. And one of the big issues with that was the diagnosis of Carly's father. And why that's important is one of the prongs. I know you've heard psychiatric stuff all week and it sort of gets old. But one of the prongs in order to see if somebody, I guess, is bipolar, one of the big issues is, has that person, or does that person have a family history? And that's why that became a big issue. And you heard Dr. Pickett get up there and he looked at Dr. Hardy's stuff, said, well, I'm going to change the diagnosis. So he said, I'm going to discount that, which takes one of the prongs away with one of the things you're looking at with Carly. The other stuff that he wanted to discount, and I thought this was interesting, is you just heard, you're reminded about SJ or SK when she got up on the stand. And she said, yeah, Carly had been hearing voices. I knew about it. Carly said that. Dr. Pickett You heard him on the stand. It's like, if you bring me credible evidence, you bring me something, I'll change my mind. Well, you had the friend say, oh yeah, I mean, we talked about it. Comes out on cross-examination, not direct, which was interesting. But it comes out, and then Dr. Pickett sits there and says, well, it's a friend, so I'm not going to count that. Okay, there's a journal. Okay, in the journal, Carly makes some notes about that she's heard voices and stuff. I'm going to discount that because I think that's her embellishing. All this stuff is all the SJ's testimony, the journal, all that stuff's happened before this situation took place on the 19th of March. And it's important because what you're seeing, and it's what Dr. Clark said, there's probably an undiagnosed, or there was an undiagnosed situation going on. It happens for a lot of different reasons. You have an individual, Carly, who's not telling everything. We know that. We know a lot more now than we did before. You heard from Miss Kirk, and I thought Miss Kirk was one of the things that was very enlightening with what Miss Kirk said. She was having a difficult time getting anything out of Carly. She really wasn't opening up. And so finally, the last session, which happens to be right before this happens, she was able to open up a little bit with her and get some more information. And in Carly's journal, there's an entry in there that talks about she likes Miss Kirk and that she may bring her the journal and let her see some of the stuff. That was something that was interesting. The other part that Miss Kirk said, she had no idea. Nobody had any ideas that this was going to happen, that there was a chance that this could happen. There were no clues. There was nothing. This is one thing I do agree 100% with Dr. Pickett on, and he said this was an unusual case. And the reason why it's such an unusual case, daughters don't go and shoot their mothers for no reason. Dr. Clark talked to you a little bit about it. It's like, well, usually you either have panic, and we saw it from the video and everything. There's no panic. He also talked to you about that there was mental issues that were going on. They had started in January. She was getting treatment. We didn't know how bad they were, but she had started getting treatment. They were getting worse, as we can tell from different things now, where we're looking in the journals and things of that nature. The other thing that's very interesting is that on the back end, once she was incarcerated and she was getting treatment, the correct treatment, she got better. And that's when she got the Celexa and the Abilify. And those medications were working. And sort of what you were just told a second ago, you have to have a stabilizer. And that's what she needed, was the stabilizer. It stopped the voices. It stopped what was going on. We go back to the 19th of March, and you see what occurred. There's no reason why Carly should have gone and shot her mother. There's no reason. What's equally weird about this whole situation, and it was in the state's opening, they talked a little bit about it. She crossed her arms. Again, very bizarre activity. She's singing to the dogs. And the most bizarre thing that occurs is this. she wants to go after Heath. Why? There is no reason. She calls her friends over. Friends are fine. If she's some sort of psychopath wanting to go shoot 500 people kind of person, if she's calling people over, those would be some of the people that she would, I guess, target. But no, what happens is she's reaching out for help. She's in a mental health crisis. You heard the video that, or the audio, I guess, of Heath when Heath was when he arrived home, opens the door, and gets shot at. Heath took the stand. He tells you to this day that wasn't Carly. The person that was shooting at him was not Carly. It's real important. He's the last person that's seeing her right there as it's happening. This is the person who knows. This is the person that sees her every day, that knows Carly. And yet he's saying she's shooting at him. If there's anybody that has a reason to, disavow Carly and say, hey, look, she shot me. I don't want to have anything to do. She killed my wife. He's sitting there saying, and he was doing it to his own detriment. And he's saying, that's not her. Something's wrong. That was not her. And that's what he was trying to convey to you. Now, the next thing we have, can I play the video real quick? Will you help me with that? We have the video from Hinds County Sheriff Officer or Deputy Chat. And we played it. And if you remember, the last thing that he says before, I guess it would help if you have the last thing, and we put it to, move it up a little bit. The last thing that he says before he mutes his body cam. Listen to what it is. He says something to the effect that she doesn't know about her mother. And before we go back and listen, remember what Shaq said, why he was muting it. He said it was a personnel issue. If she doesn't know about her mother, that she is shot and all this stuff that's gone on, she doesn't know what's going on. That's why that's important. And I want you to listen to it. You're going to be able to take this back and see and hear this video again. There's a policy, and I put the policy in evidence just so everybody's clear. They cannot do what Shaq did. They cannot mute it. They don't have, yeah, you can go ahead. We're going to watch it. How much? Okay, go ahead and stop it. I'm running out of time, so y'all will have to look at it. But this is, when you go back in the jury room, you have some decisions to make. And these are the decisions that you have to address. You can find her guilty. You can find her not guilty. And if you find her not guilty, you have two different options. It says not guilty by reason of insanity. And then you have to see if she has been restored to reason. If she has, then she's finished at this court. The other option, and this is what you have to look at, is you can find her not guilty by reason of insanity and that she has not been restored and that she's a danger to the community. And what that means is she goes to the state hospital or somebody comes, so she gets evaluated and they make the decisions on what happens to her. So when I'm telling you this, This is not, she has the keys and she's walking home. That's not what happens. We believe from all the testimony, and you can look on it here, you have the father saying it's not her, and then you have Shaq saying she doesn't know what happened. When you see those, that tells you she doesn't know what was going on at that time. We're asking you to find her not guilty by reason of insanity. And then you have to make the decision, was she restored or was she not? If she's not, she gets evaluated by the state hospital. They determine what's going to happen to her. That's what we're asking for. We want you to find her not guilty by reason of insanity.
State has 18 and a half minutes. We won't start the clock until you get everything set up. Yes, ma'am.
I have some of your exhibits here.
If you would just return them up here to the exhibit table, please, sir. Yes, sir. Restroom break? All right.
I would love that.
All right. Yeah, if y'all don't mind, we'll sort those out. If y'all have a seat for just a second, we'll sort out the exhibits. One of the jurors has indicated they need the restroom. We're going to take a brief restroom break, all right? Everyone remain seated while the jury exits. Y'all just knock and let us know when you're ready, okay?
Brian, I thought that last one that the state had on yesterday was the most self-serving. Yeah, I'm trying to decide if she's going to wake up at like the worst possible time.
Correct.
I know there's no change in your mind.
All
I don't know
we're
where I am.
We're outside the presence of the jury. Juror need a restroom break. We're in recess till they knock on the door. Not a minute longer. All right.
Yeah, that dude was awful. At least we have time to catch up. I do hope we get to see this judge again sometime, though, because he is amazing.
All right, jury's not ready yet, but for everybody in the audience, once they are, you don't need to be talking, okay? Once the jury comes in, there's no talking. Y'all are free to talk now, just not when the jury comes in. You have everything you need set up?
I think the judge wants everyone to shut up, Becca. I think if he had a sign he could just turn on that said shut up, he would.
That would be pretty funny.
It would be hilarious.
Hey, Fabby Gabby. Rude.
At least she didn't add an L.
That's all we have.
I think she added an L the other day.
Oh, she did.
All right.
Yeah.
Courtroom, I've been informed that the jurors are ready. Please no more talking.
Ah,
Everyone remain seated while the jury enters. Freeman.
I might have to jump off here in a minute because she may wake up.
Okay.
Not
Gabby
sure.
Butts. Oh, because she was in Grandma's stream the other day and she was talking about my butt.
Well, Becca.
I said, why is Becca obsessed with my butt?
The Godfather.
Yeah.
Get that, Judge, get that horse head. Oh, definitely, Sharon. 100%. Nobody wins.
There it is, Becca. Heh.
All right, final closing by the state.
Okay, little one. I think she's realizing I'm not her mother.
May I proceed, Your Honor? Let me pick up right where Mr. Camp left off, ladies and gentlemen. What he was telling you is that if you find the defendant not guilty by reason of insanity and you decide that she's been restored to competency, she'll walk out the door of this courthouse. You heard about voices. Let me tell you whose voice I'm talking about today. Ashley Smiley.
I know, right, Becca?
Ashley Smiley's voice matters. Because of Carly
All
Gregg,
right, I'll be back.
we will
Okay.
never hear Ashley Gregg's voice again. Ladies and gentlemen, you heard the very last noise she made. Carly Gregg, her daughter, took a gun, walked across the house, pulled it out on her mother, fired once, you hear her mother scream. Fired twice, you hear her mother scream. 1, 2, 3, 4. You hear the third shot, ladies and gentlemen. You saw that awful picture. You saw the stippling. You saw what she did. That person has not been restored. That person was never insane to begin with. You know what you didn't hear the defense attorneys talk about? The insanity standard. You know why you don't want to talk about the standard? Because they can't prove it. They can't prove it, ladies and gentlemen. You know what they tried to stand up here and say? The state hasn't told you why. Ladies and gentlemen, when we talk during voir dire, what do we talk about? That's not the state's burden. You won't find one place in the jury instructions that it tells you that the state of Mississippi has the burden to show you why Carly Gregg killed her mother, to show you why Carly Gregg attempted to kill Heath Smiley, to show you why Carly Gregg removed that camera that caught her actions and hid it into the refrigerator. That's not our burden. Our burden is to show beyond a reasonable doubt that she did it. And the defense attorneys have admitted that she did it. Let's talk about who needed help. Ms. Todd wanted to talk about Ms. Gregg needed help. Ladies and gentlemen, I submit to you that the two people that were begging for help was Ashley Smiley and Heath Smiley. We heard the 911 call. He says, oh my God, she's killed her mother and she tried to kill me. He says on there, please help. Send me help. He tried to say that, oh, now maybe Carly didn't mean to kill me. Ladies and gentlemen, I don't know why he's saying that, but I know that she shot him 6 inches from his head. And I know that she told Brooke Wafer, her friend, that I put 3 in my mom and I got 3 more waiting for my stepdad. You think that sounds like an insane person? No. That's a person that knew this gun right here. This .357 Magnum had 7 rounds. That's a person that knew that she'd put 3 of them in her mama's head. She had 3 more waiting for Heath, and who knows what she was doing with the last one. The why doesn't matter. They want to talk about the doctors. Dr. Pickett this, Dr. Clark that. Y'all heard him. Dr. Pickett said, yes, this is the first time I've had to testify in a criminal trial. But I have evaluated over 100 people for competency and sanity. You heard from Dr. Gugliano when she took the witness stand that she's done hundreds, if not more, evaluations of sanity and competency. Let me tell you what you heard from Dr. Clark. When the defense went to tender him as a forensic psychiatrist, he said, no, that's not what I am. I'm a child and adolescent psychiatrist. Did he render any opinions specific to children? No. Does his diagnosis of Carly Gregg matter? No. When you look at the standard in the state of Mississippi to be able to prove insanity, all right, she has a mental illness, right? I think we can all agree that those records state that from the time she was a small girl until we sit here today, that she has anxiety and depression. Ladies and gentlemen, it is undisputed that anxiety and depression do not cause someone to commit murder. It is undisputed in this courtroom that Kevin Gregg, if you believe his diagnoses, if you believe he was bipolar, schizophrenic, drug addict, all of it, does any of it matter? No, because you know what he didn't do? He didn't kill his parents. Ladies and gentlemen, the diagnosis doesn't matter. You heard, and I made notes of it. When Dr. Clark was testifying, Michael Smith was asking him, did she know right from wrong? That's what we got to know. Did she know right from wrong? He says, well, she knew something about what happened. Okay, well, she knew. Then he goes further and he said there was some level of awareness about what she was doing. Let's talk about that, ladies and gentlemen. She knew where she was. She knew who to call. She knew her mom's passcode. She knew where the loaded weapon was. You have pictures and evidence. There were other guns at the house. She didn't go pick up that unloaded shotgun and take it in there to where Mama was. No. She went in there with that .357 Magnum that she knew was fully loaded. She knew to text her friends. She knew to FaceTime her friends. She called them by the right name. She called them by their nicknames. She said, I fucked up. She said, don't call 911. You know why, ladies and gentlemen? She wasn't done with her plan. We don't have to prove why she wanted to kill Heath Smiley. All we know is she did. All we know is that after she killed her mom at 4:14 in the afternoon, she lied in wait, sent a message to her stepdad saying, hey, honey, when will you be home? She knew not to do it from her phone. She did it from mom's phone. When will you be home? Because I'm waiting for you. Sends him a thumbs up. Then when he comes in the door, what's she do? Points the gun at his head, ladies and gentlemen. She knew exactly what she wanted to do. And then when she wasn't sure if she was successful, she ran. Insane people do not run because they don't know right from wrong. Insane people do not tell people, I need help, because they don't think they've done anything wrong. Insane people do not flee the scene. Again, they do not know right from wrong. Carly Gregg knew everything she was doing that day. What Dr. Clark said from the witness stand is that he wants you to put all your common sense aside. There's a whole stack of medical records. He says, I didn't really pay much attention to the medical records. Not any of those other providers that actually treated Carly that said there was no mention of voices. There was no mention of lapses in time, these disassociations. But you know what I'm going to rely on? Oh, wait, no, I also didn't look at the text messages. I didn't think it was important to know what the defendant was doing at the time of the crime and between when she killed her mom and when she attempted to kill her dad. That wasn't that important. You know what's important? What the defendant said after she's been arrested for violent crimes. That's what he relied on, ladies and gentlemen. He said, well, Carly said that there were voices before. Pretty convenient, right? We talked in voir dire on Monday about why do people lie? Why do people lie? Protection. Dr. Clark said on the stand, Lexapro doesn't cause murder. Lexapro might cause people to be more prone to suicide. Lexapro does not cause people to murder. Dr. Clark said on the stand that disassociation, that's what Carly had, right? That's what he diagnosed her with. But he couldn't say that disassociation causes people to commit murders. In fact, what he said was that people tend to disassociate when they are experiencing trauma. Let's think about that. Common sense tells you if someone's in a disassociated state, they don't know what's going on, it's because they are on the receiving end of the violence. They're sex trafficking victims. They're prisoners of war. They're not children that are mad at their parents because they found out about their secret life. He expects us to believe that we can take the word of the defendant who has never reported, even to Rebecca Kirk, who she said she loved and trusted. She never reported voices to Rebecca Kirk. She never reported these lapses in time. In fact, you didn't hear that from any provider that's ever seen Carly. Let's take another step. Then Carly doesn't stop there, ladies and gentlemen. She tells Dr. Pickett, oh yeah, I was still having one of these moments. So let's talk about she's safe. Heck no, ladies and gentlemen. She's claiming that she's still having those moments while she's in our courtroom. During one of our hearings, she's saying she was in one of these disassociated spells. During her evaluation with Dr. Clark, she reported that she was having one of these disassociated spells. During her evaluation with Dr. Pickett, she was claiming she was having a disassociated spell. But you know what? She remembered every bit of it. I find it interesting that she told Dr. Clark that she has nightmares. She hears gunshots. You don't hear gunshots if you don't remember them. You don't have PTSD from an event that you don't recall. She told Dr. Gugliano that she gets queasy in her stomach when she thinks about what happened that night. I would too. Ladies and gentlemen, unfortunately, we've seen the pictures. We know what she did. That's not the face of someone who's insane. We don't have to prove the why. When Dr. Gugliano asked her, Carly, what's bothering you the most right now? She said, I always ask patients that when I'm evaluating them. Carly said, I'm missing school. Think about that. Not, I miss my mom. I'm so sorry that I did this. Oh, I hate what I've done to my family.
You didn't have to apologize.
I'm missing school. I asked Bennett Germany when he took the stand, you and Carly are still great friends, right? He said, best friends. Y'all talk all the time? Yeah, all the time, even now that she's in jail. I said, Bennett, on any of your calls, has Carly expressed remorse for what she has done? He took that stand and he said no. I want to talk about Bennett too. He said, well, I was asking him a question at some point. He said, I'm sorry, can you repeat the question? I zoned out. Ladies and gentlemen, we've all had a moment where we've zoned out. We've all had a moment where we've driven down the road and got there and thought, how did I get here? I don't remember, but I knew I drove here. I tell you, when I have those moments, I'm not insane. I know exactly how I got there because I was the one driving the car. I know right from wrong, and Carly knew right from wrong that day. There is no record, no medical record of Carly hearing voices before this. I want to talk to you about some of the things, some of Carly's actions. Let's talk about some of her willful actions. First of all, I want to show you these two. Let's not forget this. These were recovered from inside Ashley Smiley's brain and neck. Who put them there? Carly Gregg. Carly Gregg's willful actions. Let's talk about that. We talked about she knew where her house was. We talked about she knew that her mom was upset with her. She told Dr. Pickett, yeah, my mom was very upset. The defense wanted you to believe that everything was hunky-dory that day. It wasn't. We've seen the videos. She may not have been yelling, but she sure was upset. We know that Carly knew her mom's password. We know that she intentionally pulled the trigger not once, not twice, but 3 times, shot her in the head. We know that she called her friends over. We know that she told them don't call the police. We know that she wouldn't let them know what was going on. We know that she tells Brooke, right? Let's talk about the tampering with evidence. She tells Brooke when she comes in the house, one of the first things she asks is, are you queasy around dead bodies? Ladies and gentlemen, use your common sense. What does that mean? I know if I'm asking somebody that, it's because there's a dead body. She knew that she had killed her mom. She tells Brooke, I got 3 waiting for my stepdad. She knew that she was going to shoot her stepdad. She also tells Brooke something important. Oh, don't worry. I pulled the cameras down already. I pulled the cameras down. She knew enough to rip that camera off of where it was, hide it in the refrigerator. Was it a perfect plan? No. Nobody ever said her plan was perfect. That's why we're here. But ladies and gentlemen, that's not insanity. That's not insanity. I want to talk about Deputy Shack and his interaction. Mr. Camp said, oh yeah, he's saying she doesn't even know about her mother. We heard from Deputy Shack. He took the stand. He said she never asked about her mother. Ladies and gentlemen, you know the only person she asked about in her interaction with law enforcement? How's he? You know why? Because the only thing Carly Gregg didn't know from that day was whether or not she was successful in killing Heath Smiley. That's the only thing she didn't know. Again, the defense wanted to talk about it's the highest burden of proof. We have the highest burden of proof in criminal law. The state of Mississippi has to prove beyond a reasonable doubt that Carly Gregg intended to kill her mother and did kill her. We have done that. They don't dispute that. We have to prove that Carly Gregg intended to kill Heath Smiley and was unsuccessful. They don't dispute that. We have to prove that Carly Gregg intended to remove evidence and hide it. We've already proved that. They don't dispute that. The only thing that the defense wants you to do is to have sympathy for the defendant, to believe this story that she's made up after she's been arrested. Dr. Clark talked about that on the stand, right? He admitted that there's research out there that shows that there is a large population of people that claim disassociation after they have committed homicide. And we asked him, why? Secondary gain. What's secondary gain? So I don't get in trouble. Pretty convenient. If I don't remember what happened, I was having an out-of-body experience. Maybe they can't get on to me. Ladies and gentlemen, don't fall for that. That does not make sense. I want to talk about some of Carly's journals and some of the text messages. The text messages are in evidence, the ones that she sent to her friends between the time she killed her mom and when she attempted to kill her stepdad. One of them's not, but Thad testified from the witness stand that after he showed up at her parents' house, he and Carly were having a discussion, and Carly said, oh yeah, my mom was holding me down in the chair. She wouldn't let me come out there. And then she texts him later and says, I almost murdered my parents. She was so mad in February that she tells Thad, I almost murdered my parents. And then when I asked Heath about it, when he took the stand, he said, no, Carly wasn't mad. Carly never was angry. He says, Carly never yelled. Ladies and gentlemen, she told us in February what she was going to do. I want you to look at her journals. There's a page back there that says, what do I believe? There's no God, heaven and hell are false. You writing your own destiny. And these two stand out to me, ladies and gentlemen. She told us what her intent was. You don't need family, and it's okay to be evil. There's another one I want you to look at. Dr. Pickett talked about it. She wrote, water, fire, earth. Water, fire, earth. She circles fire, ladies and gentlemen. And she wrote, these are Carly Gregg's own words. Ms. Todd stated when we got started the other day, what's better, watching a video of what happened or hearing somebody talk about it? Well, I submit to you, we have all of the above in this case. We got to, unfortunately, watch a video of what happened. We've seen photos of what happened. We have audio of what happened. We have the defendant's journals and text messages telling us what happened. She says, I choose fire. It is powerful, beautiful, and deadly. These are the traits I desire, so I choose fire. Ladies and gentlemen, that lady right there chose fire. She chose to murder her mother, tried to kill her stepdad, and then tried to cover it up. We ask that when you go back to the jury room, that you'll look at all the evidence, that you'll consider the testimony that you've heard, that you will not be misled or confused by the fact that the defendant tries to put a burden on the state that does not exist. We do not have to prove the why. We will likely never know the why, but we know that Carly Gregg is guilty of murder, attempted murder, and tampering with physical evidence, and we ask you to find the same. Thank you.
Yep. Right on.
All right. I need Mr. Don Bass and Mr. Philip Hunt to stand, please. Apologize, gentlemen. Watch y'all. Y'all are paying a lot of attention, but y'all are the alternates. At this time, I'm going to ask Madam Bailiff to escort them to the other courtroom if it's open or the other jury room if it's open. Please gather your things out of the jury room, though. Once the bailiff let me know that the alternates have been separated, I'll release you to begin your deliberations. Please do not begin your deliberations until you receive the instructions of the court and all the evidence. Many times jurors find it helpful to pick a foreperson from among their group. Foreperson has no more power than any other person. Highest qualifications, you should be able to write legibly so we can read any verdict, okay? Second thing a foreperson can do is call for a vote. Many times disagreements can be resolved by simply calling for a vote and finding out where everybody stands, all right? That being said, let me know once they're separated. Did everybody fill out a lunch menu too? Okay. They're separated. All right, ladies and gentlemen of the jury, you can retire to begin your deliberations.
Start the clock. 1:45. Oh, not there.
All right, the record will reflect we're outside the presence of the jury. I'm going to ask both sides to make sure Mr. Shipley here has a cell phone number where you can be reached, both sets of attorneys. Within 10 minutes of the jury reaching a verdict, I expect y'all back in the courtroom ready to go either way, okay? I want y'all to get together, make sure all the exhibits are present and accounted for, and that any exhibits marked for identification are separated. All right, we'll remain in recess until such time as the jury reaches the verdict.
I give them 2 hours max. I knew you'd say that, Flash fan. I think the consensus yesterday was between 2 and 5 hours in the poll, from memory. Yeah, me too, Treasia. I think the consensus yesterday was between 2 and 5 hours. I'm getting an echo. I reckon it'll be tonight or this afternoon, Nidawal. So what time is it in Mississippi now? 10:47? Wow. I 100% think she's guilty. I don't think there is... yes, I think she has mental health issues. I don't think they are the extent of what...
Sorry, I'm feeding Madison. I'm going to pull up Sarah Boone's hearing from yesterday just to keep us occupied. And I'll keep an eye on this. So give me just a sec.
I agree, Treasia. Yep, who doesn't have mental health issues? And you can't blame adolescents. I think she had some mental health issues, but nothing to the extent for which they have implied. And I think she has played them all for a fool. But that's just my opinion. For what it's worth.
Comfortable, sir, but because we have your co-counsel appearing.
Sorry, trying to do everything with one hand. So apparently she's going to try to claim self-defense on the whole suitcase thing. Because why not when you got nothing else? Alrighty, I'm going to hit play. Hopefully this sounds good. I'll be back in just a minute. As soon as I get done feeding this hungry baby that I'm sure you can hear eating.
Judge, do you want me at the podium?
However you feel most comfortable, sir. But because we have your co-counsel appearing virtually, I would ask that you direct any argument into the microphone so that they might be able to hear it, sir.
So I filed on behalf of Sarah Boone this motion for statement of particulars.
You have to find it
And in my
online.
motion, I quoted the language and the information that she was charged with. And the pertinent part charges Sarah Boone on the 23rd day of February of 2020 in said county, Orange County, violating statute 782.04, paragraph 2, by an act eminently dangerous to another and evincing a depraved mind regardless of human life, did kill George Torres. Judge, that's about as bare bones of an information as you can file in a case. I know anytime there is a weapon used, she usually shot with a firearm, use that type of language. That is as bare bones. It doesn't even spell out all the essential language of the jury instruction, which I followed. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, the victim is dead. 2, the death was caused by the criminal act of the defendant. Now, there is no language in the information that alleges what criminal act Sarah Boone committed that caused the death of the victim, Mr. Torres. This is a unique case, Judge. It does not involve a firearm, which I believe many of these cases do. I'm sure you're well aware. The state's well aware of the report, the videotapes in this case, and the overall general facts about the suitcase and Mr. Torres being in the suitcase asking to be let out by Ms. Boone. But the state, in their charging document, has failed to say exactly what it is that they believe is the criminal act that caused the death by Sarah Boone. Some information that the defense could receive from them so that we could properly prepare a defense for Ms. Boone. In count 3, the unlawful killing of the victim was an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. It goes on to define an act as a series of related actions arising from or performed pursuant to a single design or purpose. We have no information, no particulars in the information that explains a series of related actions arising from and performed pursuant to a single design or purpose. None of that language is in the information that would let us know what it is they're claiming that she did or series of acts that she committed that constituted the cause of the death of Mr. Torres. The definition goes on to explain that an act is eminently dangerous to another or demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. What is the act or series of acts that an ordinary person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury? 2, is done with ill will, hatred, spite, or evil intent. What acts or actions by the defendant did they present or will they intend on presenting in the trial that would tend to indicate that she had ill will, hatred, spite, or evil intent towards Mr. Torres? And 3, is of such a nature that the act itself indicates an indifference to human life. Again, some explanation that give the defense, my understanding of the rule of criminal procedure, the defendant has a right to know the charges against them with specificity. Upon request, the state must provide specificity and clarification on the details of the alleged offense in order to minimize surprise at trial and ensure that the defendant's rights are protected. The rule requires that the information shall, in plain, concise, and definite written statement of the essential facts constituting the offense charged. In this case, based on the bare bones information that has been filed in this case, it fails to inform the defendant and the defense counsel of the particulars sufficiently to enable the defendant to prepare a defense. Thank you.
Response.
Judge, the state stands by its written response that was filed on September 5th of this year. In addition to that authority that is cited therein, the state would also cite State versus Pajon, Pajon, 374 Southern 2nd, 1070, Florida 3rd DCA, 1979, and Sutherland versus State, 305 Southern 3rd, 776, Florida 1st DCA, 2020.
Can I have the second citation again? 305 Southern 2nd.
Southern 3rd, 776. And what all these authorities stand for, dating back to well before there were any discovery rules crafted in, I think, 1968, is the position that it's an extraordinary remedy to be given a statement of particulars in a case. The information in this case tracks the statute. That is what is required. There is nothing confusing about it. There aren't multiple allegations of second-degree murder on the same day, leaving her confused as to what we are talking about. There is no exposure to double jeopardy. There's no element of surprise. The state of Florida has provided discovery to the defendant in 2020. The state waived any opinion work product arguments that it had under Williams versus State in going ahead and providing the defendant exactly which exhibits we're going to enter in a trial, exactly which of the witnesses we've disclosed will be called at trial. And their motion does not set forth why it is specifically that they don't understand what she is accused of doing and how. In fact, opposing counsel cited the videotapes, the videos that were taken on her phone while the decedent was in the suitcase begging to be left out. And then what they didn't mention is what she said during these videotapes, which certainly would constitute the mens rea for second-degree murder. So it's our position that they have not stated why it is that a statement of particulars is necessary. It's an extraordinary remedy. They have all the discovery. Not only do they have all the discovery, they have the narrowed down list specifically as to what will be introduced. And they are clearly on notice of what constitutes the acts and the mens rea because they have mentioned those videos that were taken on her phone. So it's our position that this is not one of those extraordinary cases that necessitates a statement of particulars. There are cases where, for example, somebody commits multiple acts of battery against a victim, perhaps an hour apart, 2 hours apart, and comes back. And it's unclear as to what the state is talking about. If counts 1, 2, and 3 all say battery on X day. There are informations and indictments that span years that don't get statements of particulars articulated to the defense. In this case, the date is specific as to February 23rd, 2020. The metadata on the 2 videos that were taken from her phone are both from the 11 p.m. hour of February 23rd, 2020. Given all the discovery in the case and the amount of narrowing down that we've already done, there is no need for a statement of particulars in this case. Thank you.
Thank you. Any response?
My understanding of the law is the court has broad discretion on this issue about whether to require the state attorney's office to give more particulars about the offense. And this is somewhat of a unique case. And the state attorney just mentioned where there was prior incidences of violence or battery that occurred prior maybe to the death and whether or not that was relevant or admissible. That's the case we have here. Judge, I'm sure you're aware that Mr. Torres suffered from some blunt force trauma that was unrelated to the death. The medical examiner who did the autopsy took photographs and described that there was blunt force trauma on Mr. Torres's body that did not cause the death, that was unrelated to the cause of death. And that information has not been detailed, whether or not it's relevant to his death, whether or not they're going to try to tie that in to Mr. Torres's death. And if not, if we're relying on the medical examiner's explanation of the cause of death, which was asphyxiation, suffocation, then there's a question about whether that information is.
But is there anything that's missing under the statute? I understand your reliance on the jury instructions, but what's your response to Mr. J's position that it tracks the language of the statute wholly and completely, which it seems to?
Well, I have the rule for motion of particulars then. If that's the case, then in every case in the country, you just have to track the statute, and at no time a court would ever order a motion for statement of particulars.
But the date's there, the time's there, where it happened is there, the underlying charge is there.
I understand, and I explained that this is not a shooting where death would occur fairly quickly after multiple shots, that this was an unusual death, asphyxiation over a period of time, which we don't even know whether it was the day before or the next day. There's questions about that. The injuries, the blunt force trauma that the medical examiner is claiming that they're there, I believe is going to testify they could have been there 24 to 36 hours before. We don't know when those prior injuries were. They're fairly fresh, but they can't state that they were close to the time of death. Again, they weren't related to the cause of death. So there are situations in the law based on the unique set of facts that a court feels compelled, yeah, I have the discretion and I feel like for the defense to properly prepare for this case due to this unique set of facts that I think there are some details that you must give. There's blunt force trauma. We don't know exactly when it was. We know it was fairly recent. And the medical examiner says the cause of death is asphyxiation. He doesn't know where it was environmental or not. He gives two explanations. So there's a real question about that. And of course, we'd like to know what theory they're going under and whether or not they're intending to introduce evidence of this blunt force trauma that occurred sometime prior, and what exactly they're claiming that she did that constitute. Is it just the video, the 2-minute video that everybody's seen, or the suitcase video? Is it that? Because there was a lot that occurred prior to the video. There was a lot that occurred after the video that's not on the video. So is that what they're referring to in this narrow window of just tracking the statute? And I go back to there wouldn't be this rule in the criminal procedure if there wasn't a time when a statement of particulars was necessary. Thank you.
All right, thank you, sir. The court has reviewed the motion, reviewed the authorities provided, including the additional authorities, State v. Pajan, 374 Southern 2nd, 1070, and Sutherland v. State, 305 Southern 3rd, 776, and relying on State v. Peel, if the indictment is sufficiently full in its allegations of fact constituting the crime charged to enable a person to plead to it. The greater part of the reason for allowing particulars does not exist. The application was not so much for a bill of particulars as for a detailed statement of the evidence by which the state proposed to prove its case. If the defendant was advised of the nature and the cause of the accusation against him and had notice of the dates on which the acts constituting the offense were committed, there was no necessity for the bill of particulars. All this information was given in the indictment. And that is at 154 Southern 2nd, pinpoint 912. It sounds like, based on your argument, you're looking for the particular evidence as to the cause of death and the meaning of the death, which, based on Peel, is not something that falls under the ambit of a motion for particulars. So reliance on State v. Peel, understanding the age of this case as well, understanding there have been multiple lawyers who have filed responses denying the charges in their notices of appearance, your motion is denied, looking at the totality of the circumstances.
Thank
you. Moving now to, give me a moment. And I think we could probably address these collectively. The defense's motion for additional discovery filed September 2, and the defense's second motion for additional discovery filed September 6th. Similar to the first motion, the court has reviewed all the authorities and those motions. Mr. Owens, you may proceed, sir.
Can I approach the bench?
Yes. Thanks, sir.
Judge, we're going to handle these both collectively, and I believe we should. The first motion for additional discovery was filed on September the 2nd at 8:30, and then the second motion for additional discovery was filed on September the 6th. The first motion refers to the rule 3.220F for additional discovery. On a showing of materiality, the court may require such other discovery to the parties as justice may require. Specifically, the defense is requesting the Office of the State Attorney to provide a written policy of the Orange County Sheriff's Office relating to in-house interrogation procedures, in particular, the policy in place at the time of the interrogation of the defendant at the Orange County Sheriff's Office, which was back in February of 2020. And then the second motion for additional discovery, specifically, the defense requests the Office of the State Attorney to provide the standardized Miranda rights written policy, the form, and the card of the Orange County Sheriff's Office relating to Miranda rights form utilized and read directly to any suspect before any interrogation. Now, the argument by the state is well taken. The defense does have a duty to try to gather the information independently of the state attorney's office. And we did make a request to the Orange County Sheriff's Department back on September the 10th. And the request was for the written policies and procedures of the Orange County Sheriff's Office relating to the in-house interrogation procedures, in particular, the policies and procedures in place in February of 2020. And the written policies number 2 and procedures of the Orange County Sheriff's regarding Miranda rights, written policy, the form and the card relating to Miranda rights utilized and read directly to the suspect before any interrogation in effect in February 2020. So as you know, Judge, I don't know if you've actually watched the 2-hour interrogation, but the day after this event, she was asked to come down to the Orange County Sheriff's Office under what my client believed was something other than an interrogation. When she got there, she was directed into a room. And I don't know, like you said, you haven't had a chance, but there are some serious issues about whether or not that was coerced, whether or not Miranda rights were fully read. I do not believe they were. I believe some of the statements that the lead detective said before she started the Miranda rights are coercive. She was in a room where she could not leave with 2 homicide detectives. One was wearing a firearm, and she acquiesced to authority based on an improper reading of Miranda. I wanted to file motions to that effect. We've got trial coming up October the 7th. I wanted to wait to get those policies. I wanted to wait to get the Miranda rights forms. The homicide detective actually reads it from a card. And I believe she read it incorrectly, and she left out the main question at the end. So the proper thing to do is to get that information and make sure it's verified before you file in good faith a motion to suppress her statements. Well, the state attorney has tremendous power. I've made this request, September the 10th. Now it's, the 19th. And I'm in line with other public records requests there at the Orange County Sheriff's Department as to when I get this information. The state attorney could have gotten it the very next day if they would have made that request. That's why I filed the specific motion for the additional evidence. Time was of the essence. The court denied my motion on September 3rd to continue the case. We've got about 18 or 19 days left for trial. I'm still waiting. I've still got to receive that information. I've got to file the motion. I've got to set it for a hearing. I've got to subpoena the two detectives, the two homicide detectives. We've got to have a hearing with 18, 19 days left. I'm still waiting on this information from the sheriff. I've made a good faith attempt. Time is ticking. The state could get that information to me tomorrow. Thank you.
Response.
Your Honor, it's not Mr. Owens who's on trial, it's Sarah Boone. Sarah Boone was interviewed by the Orange County Sheriff's Office on February 24th and 25th of 2020. Now, some 4 years and 7 months later, there's this exigency not created by us, created by them. It's the defendant who has not done this for 4 years and 7 months. Now, turning to the merits of this, they are asking for discovery from a third party. Any discovery request, whether it is of the state or of a third party, has to involve allegations that this information is reasonably calculated to lead to admissible evidence or be pertinent to some analysis in this case. They have not stated why in their motion, and the arguments in court today do not state why it's pertinent either. The case law does not say statements are inadmissible or only used for impeachment if the law enforcement officer violates policy. There's no case law that says statements are inadmissible or only used for impeachment purposes if they don't read from their Miranda card properly. What the case law states is statements are inadmissible if there are Miranda violations and only used for impeachment, or if statements are involuntary, basically through promises, then they can't be used for any reason. But nowhere in this analysis does it matter to any degree what a standard issued Miranda rights card looks like or what their policy is on interviewing. What they do have and what the defendant has had since February or April or whenever discovery went out in 2020 was a videotape of these interviews. There has been absolutely nothing stopping anybody from filing a motion to suppress if they believed under the case law, relief could be granted under the law. And the law does not have any analysis regarding standardized issued Miranda cards or policies of law enforcement agencies. And I don't believe that's admissible at trial either. If they did not violate the Constitution of the state of Florida or the United States in compelling an involuntary statement or by violating the dictates of Miranda versus Arizona, then questions about whether they read from their right standard card or if they violated policy should not be admitted in trial because it does not help the jury understand whether or not an element of the crime has been proven. It's not a part of the lengthy jury instruction now that we give about defendants' statements. There's nothing in there about, well, did they violate their Miranda card? Did they violate their policy? So first of all, the state's position is they have not asserted the materiality needed to get discovery ordered by this court, which would be reasonably calculated to lead to admissible evidence or to lead to it being found inadmissible by the court. And then secondly, it's on them to conduct this discovery, and coming in and saying that I can snap my fingers or not snap my fingers and get it for them instantly isn't evidence either. So it's our position that the request should be denied primarily because it's immaterial, and then secondarily because it's on them. She's been aware of these statements since February 24th and February 25th of 2020. Thank you.
Thank you. Response to the materiality, please.
Well, Judge, I believe the prosecutor is wrong. One of the jury instructions, standard jury instruction in criminal cases said that essentially a statement has been placed before you that's made by the defendant. And I don't have the language here, but it should be weighed with great care and caution to make sure it was freely and voluntarily made. These are some, but not all of the circumstances that you should consider in deciding whether or not the statement that was made by the defendant was freely and voluntarily made. If you decide that it was not freely and voluntarily made, that evidence should not be considered by you in this cause. So even if we filed the motion, we got the information, the additional discovery that we need in good faith for me to file it, if we received the information, I typed up the motion, we had a hearing, the two detectives testified, and the court ruled that the statements were not suppressible, I could still bring those facts into the trial of how the mistakes that were made by this lead detective in the coercive statements that she made, as well as not giving the full Miranda rights form and getting a full consent from my client, that goes into evidence for the jury to decide whether or not to consider the statement at all. Thank you.
So where's the violation of the Constitution then? Assuming you're correct and assuming that the Miranda card, something was missing, what's the issue?
It's coercive. The statements that the lead detective, the female detective makes, there's 2 or 3 statements she makes.
Now you have to understand, I'm in a vacuum here because I haven't watched the video. I'm not asking you to play it.
I probably should have.
But I need a little bit more context as to these statements because I have unfortunately no frame of reference.
But she says that, number one, the date of this event, they seized her phone at the scene. She was told that they were going to bring her phone back to her, back at her apartment the very next afternoon. The female detective called her, or Sarah called the female detective about the phone. The female detective said, I'm pregnant, I'm not feeling well, I don't want to drive out there to give you your phone. Would you please come to the sheriff's department so that we can give you your phone? Sarah Boone got there and saw that there was a desk or a place there to retrieve the items, and she saw the male detective and said, is this where I go to get the phone? He said, no, we got it back here in this room. Come back here in this room and we'll get it. When they walk back in there is when the video turns on, and now they're in the interrogation room. She's got a list. Sarah Boone has a list of things that she was wanting to ask them. And the female detective says, look, we got the autopsy back from the medical examiner. We've got to talk to you about that. 2 times she said, we must, I don't think it's must, we've got to talk to you. She goes, okay. So I got to read you these Miranda rights again. And again, she had read them. There was a statement that Sarah Boone gave. Of course, she gave a general statement to the first deputy that responded to the scene. She was wearing a body cam, so that deputy had called the 2 homicide detectives, but it took them a while to get there. So she asked Sarah Boone what had happened, and Sarah explained that situation. After the detectives got there, they took a general statement from Sarah, but at some point they got into one of the squad cars. And I believe it was Sarah Boone. I believe it was the female detective and the male detective. And she was read Miranda rights, again, incorrectly, and she gave a statement. So now the next day, she's back in the interrogation room with the 2 deputies, the 2 detectives, and the lead detective says, we've got to talk to you about this autopsy. Giving her the impression that's what they were going to talk about. But I've got to read you these Miranda rights. And she said something, and Sarah said, protocol? Because they had told her in the first Miranda rights that this is just protocol. We have to do this before we speak to you. And she said, yes, protocol. So based on those statements that we've got to talk. You have to talk to us. We've got the autopsy. Led Sarah to believe that they're going to talk about the autopsy. In addition, then she starts in the Miranda, judge, she made a mistake on it. I don't know if it's an honest mistake, but in her probable cause statement, she said, I read the rights verbatim. The constitutional Miranda rights I read to her verbatim. That is not true. Fortunately, we have it on audio. Fortunately, we have it on video. There is a legitimate question about whether that statement, that 2-hour interrogation, is admissible in this trial. That's what I'm going to show the court. I'd like to get their policy just to see.
What does the policy have to do if those statements were inadmissible? What does the policy have anything to do with that analysis?
To see if they,
Because if you're saying you have a deposition, I'm assuming it's a deposition of the female detective, said I read it verbatim, and you're
no,
telling,
that's in the probable cause statement.
okay, that it was
formulated-
read verbatim. Okay,
yes, that
excuse me.
formulated the arrest report. It was a supplemental report or either the actual probable cause report.
And the representation in there is, it was read verbatim.
That's
Now,
correct.
you've reviewed that interrogation. It's your position that it was not read verbatim. What does the policy have anything to do with that issue?
I think,
That's a simple constitutional issue, right?
yeah,
If there's a case law that buttresses that position and that de facto is a violation of the Constitution, ergo, that confession or statements are not admissible because of the violation of the Constitution. What does the policy or the Miranda card have anything to do with anything if you have the video and the audio?
well, the Miranda card is going to show that she actually omitted the last question. Okay? So the Miranda card is there for a reason. I don't know if they have them in the interrogation room or every deputy or homicide detective is issued that card, but it's a small card. But I believe it's going to say on there that you've got to get the waiver. There's 2 questions at the end, which is, did you understand the rights that I've just read to you? And the next question, understanding these rights, do you agree to speak with us now? That question was not read. It was omitted. I don't know why. She's sitting there reading it, and
Does the fact that that question was not read impact constitutionally under case law the admissibility of those statements?
I believe so.
That doesn't
with
answer
her
my
other 2
question.
statements.
Respectfully, that doesn't answer my question. I understand what your belief is, but where's the case law that you can provide to the court?
I'm not ready for that, Judge.
Okay.
I'm going to file a motion to suppress, and I'll supply you with the case law, but I'm not ready for that. But the reason I wanted the policy, getting back to your first question, is because I'm sure the policy is going to say you don't make any pre-Miranda statements like, we've got to talk. We've got to talk about this autopsy. Those type statements are improper, that they're used to coerce somebody to talk. And I understand the detective, they had these videos, the 2-minute video and the short second video, and they had found it on her phone. So the homicide detective was chewing at the bit to get her to talk. So she was trying to induce or influence her to speak to them and to not exercise a fundamental right, not to speak to them without a lawyer being present. So she made those 2 statements preliminarily that I believe the policy is going to say you don't do.
Okay. Mr. J, anything else, sir?
Just the Orange County Sheriff's Office doesn't set the policy for what is admissible evidence in court. The United States Supreme Court does, the Florida Supreme Court does, the 6 DCA courts do, and then ultimately, following their guidance, you will decide whether or not a statement is admissible in the state's case in chief or if it's only available for impeachment. But whether or not, let's say hypothetically, she read the Miranda card 100% accurately. She followed policy 100% accurately. The state of Florida can't come in and say, Judge, I know they violated U.S. Supreme Court case law, but they followed the sheriff's office's policy. So these statements are clearly admissible. And the contrast is exactly the same. Whether or not they followed policy or read the Miranda card accurately has nothing to do with the analysis as to whether these statements are going to be admissible or only admissible for impeachment. And I don't believe that under the case law, they can come in if those statements are admissible and argue to the jury, they violated policy. They didn't review, they didn't read everything on their card. They violated. How does that help the jury decide whether or not the statement's voluntary? It doesn't matter what the policy is. It doesn't matter what the card is. What matters is whether or not they say the words that are required by the United States Supreme Court or the Florida Supreme Court or the 6 DCAs. That's what matters. That is what determines the bar for the admissibility in the case in chief or an impeachment.
Okay, thank you. All right, thank you both for your arguments and your positions. In reviewing the authority provided by the state, which the defense has conceded is taken is what it is. I think state versus right is the guiding light for the court here. 803 Southern 2nd, 379. In reviewing that analysis, the defense has put forth an effort to do so. It's not up to the state to prove up anything for the defense. At this point in time, both motions for additional discovery are denied in accordance with State v. Wright. Moving now to the defense's motion to appoint forensic psychologist filed September 2, and defense's motion to appoint crime scene reconstructionist and death investigator filed September 2. I did receive JACS's response in that my judicial assistant confirmed that they are not asking to participate in this hearing. And we did confirm that earlier this week. Similar to the other motions that we've heard today, I have reviewed them. Mr. Owens, you may proceed with anything else, sir.
Judge, I have filed the amended motion for declaration of indigency and payment of due process cost.
I did see that, sir.
And then there are 3 motions. I don't know if you got the third one.
Are you referring to the motion to return property?
No, relating to cost. Relating to cost.
I don't know that I have. I'm just going by what the notice of hearing reflected. So no, I don't.
I filed a second amended notice of hearing. I don't know if you got that.
Was it forwarded to my office? Because if it wasn't, I don't know.
I'll
that I
have to
got it
ask
yet.
Margaret. I don't know.
Okay.
But I filed a second amended notice of hearing. Can I give
Please.
you my copy?
And Mr. J, have you seen that, sir?
State doesn't have a dog in the fight with the expert witness.
Understood. Thank you.
Judge, what I had done
Don't
was
see
I
a date
had,
on here, Counselor. When was this sent? The certificate of services contains no date.
it was filed this afternoon,
Okay.
this morning.
Okay. All right, what is the other motion related to cost, sir?
Well, there's one for the appointment of the forensic psychologist, Dr. Julie Harper, and it's non-pro-tunc. I'd like it to be retroactive to when I actually had to hire them. As you know, I came on the case late, August, I believe, August the 30th.
Correct.
And then I asked Dr. Harper to go down and see Sarah Boone. She lives, Dr. Harper lives in Okaloosa County. And she came down to Orange County, I believe, the Thursday after we had the hearing on September the 3rd. I believe that's when the court denied my motion to continue. And so, as you know, we had to file the notice of intent to rely on battered spouse syndrome within 30 days prior to trial, which would have been that Saturday, I believe. So she went down, Dr. Harper went down and saw Sarah again. As you know, Dr. Harper had seen her several times in the case, back in 2020, maybe 2021. And so she had the most knowledge of, I believe, any of the experts that have evaluated Sarah Boone over the course of these 4.5 years. She was the one expert that had seen her the most. I asked her to go down again in the hopes that the court would appoint her. And she agreed. That was, I think, on a Thursday. She called me that morning, Friday morning, and said, yes, I do believe that she suffered from battered spouse syndrome at the time of this offense. Based on that, I filed the motion. But so she jumped ahead and did some work prematurely before she had been appointed. So I'm asking for those costs for her to do the earlier work, that be considered, as well as Dr. Berkland. Dr. Michael Berkland is a crime scene reconstructionist and death investigator, and I'm asking for the court to consider paying for his fees as well as his transportation costs, as I have for Dr. Harper. Again, to be retroactively to the time I asked him to be in work on the case. And then the last,
When was that? You're asking nunc-pro-tunc to win on that, also to the August 30th date of your
Yes.
notice of appearance?
if possible, yes. That's when I officially got on the case.
Now, as to the third motion for cost, I don't have a copy of that, unfortunately.
Can I approach?
Yes, please.
Judge, I mentioned this expert, Dr. Michael Brannon, in that hearing that I think we had on September the 3rd. He's a clinical psychologist. If you'll recall, I had mentioned him. He had served as an expert in the Marsha Thompson Palm Beach County case.
I recall.
And so, as you know, he serves a different role as a clinical psychologist. Dr. Harper is serving as a forensic psychologist. And
Do you know what JACS's opinion with regard to the motion to appoint clinical psychologist? Because the email that you attach as Exhibit A to that appears to be Mr. Lake's email regarding the other two motions regarding Dr. Harper and Dr. Birkeland. And it doesn't address Dr. Brannon, and notably JACS isn't here.
I don't have an answer for that. Maybe we could table this.
I think the state has, I'm assuming, no dog in this fight, similarly as they had with the other two.
The only request in this area that the state is going to make of the court is to, under its discretion, under 3220, order these experts to produce written reports. We are on the eve of trial. I do not need one from Dr. Julie Harper. Her deposition is set October 1st.
Mhm.
These two other people, I have absolutely no idea what they are going to say, and we would, I'll file a written motion and a proposed order and send it to opposing counsel. But that's what the state's request is going to be on the other two experts.
Yeah, I don't know if I'm going to have an objection to a written report or not. I may, but I'd like to see what the motion says
Sure.
before
And
I make a
I'm not-
decision. But yes, Judge, we have scheduled Dr. Julie Harper's deposition at her office in Okaloosa County on Tuesday, October the 1st at 10:30 a.m. Eastern Standard Time.
Is that in person or is that virtual?
Central.
Is that in person or is that virtual?
I believe
Okay.
the state's flying in, and I'm going to be there, Judge. That's the county over from me, Santa Rosa County. So about an hour drive for me. So I'll be there in person. We're going to have probably Kevin Beck that's going to appear by Zoom.
All right, so here's what we're going to do. JACS has provided their response, and their response was not appended to the motions that were filed because that was prior to the amended motion seeking indigent costs that you filed, Counselor, on behalf of Ms. Boone. I'm going to hand file with the court now the September 9th correspondence from JACS reflecting that that can be utilized in lieu of a formal response. I'm going to grant your motion to appoint a forensic psychologist dated September 2, 2024, non-protunct those costs to August 30, 2024. And with regard to the other motion, the motion to appoint crime scene reconstructionist and death investigator, I will also grant that and appoint Dr. Michael Berglund, non-protunct, to August 30, 2024. With regard to the motion to appoint clinical psychologist, when was this motion filed? Similarly, the certificate of service does not reflect a date.
Let us check real quick, Judge.
Sure.
Give me a minute.
Yeah, you're good. Excuse me.
No, Dr. Michael Brannon. It had to be filed. Michael Brannon.
While you're waiting on that, I do see on your second amended notice of hearing, you also requested the amended motion for declaration of indigency and payments of due process costs also be heard. When was that motion filed as well, Mr. Owens?
It was filed just prior to filing these amended ones. It had to be filed prior to my motions for appointment of these experts.
Give me a second. Okay, so the motion to appoint the clinical psychologist regarding Dr. Brannon, was filed yesterday. The amended motions regarding Dr. Birkeland, an amended motion regarding Dr. Harper were filed yesterday. as was the amended motion for declaration of indigency and payment of due process costs. That motion has not yet been granted. It is going to be. So the amended motion for declaration of indigency and payment of due process costs is granted. The amended motions regarding Dr. Berglund and Dr. Harper are also granted non pro tunc to August 30. With regard to the motion to appoint clinical psychologist filed 9/18, I'm going to ask Ms. Barrios, my judicial assistant, to forward that directly to Mr. Lake. And I know that she's watching this virtually. If she's able to do that now, I would greatly appreciate it, and see if we can get his response to that this afternoon. And maybe we'll be able to address that. It may be a similar vein as to the prior response that JACS had provided. Moving now to the motion for return of property, or in the alternative, motion for independent exam by the defense, filed September 18th. Similarly, with everything else, I've reviewed that and the authority, and I have reviewed the state's response to a defendant's motion for return of property, or in the alternative, motion for independent exam by the defense. Mr. Owens, you may proceed, sir.
Judge, I believe the state's response is well taken. And I believe that what we need to do is get an expert of our own that can do the phone extraction and meet with the state attorney and the sheriff's department and extract the data, all the data that we need from her phone. So we would submit that the property should not be, based on the authority the state attorney has cited, the property should not be returned to the defendant since trial is still pending. But in the alternative, we're asking for an independent exam by the defense.
Response, if any?
As the state has stated in open court while she was pro se, that is absolutely fine. And I've even suggested a name.
Has the defense ever performed an evaluation of the phone? And the reason I ask is there were prior experts that were appointed in the realm of electronic evidence.
Mr. Cacciatore may have the answer to that question. I don't, but I know that the state, as I stated in my response, we've never prevented anybody from doing that. And as the homicide supervisor, everybody in the unit knows how to go about doing this and allowing a digital forensics examiner hired by a defendant to go and work with the law enforcement team and get another imaging if they are not satisfied with the imaging that has been provided.
Mr. Cacciatore, good afternoon, sir. Can you hear us? And if you can you announce your presence for the record, please?
There has not previously been a forensic exam of that phone by a previous defense counsel.
Okay. All right. Thank you very much, sir. There was a John Sawicki that was appointed back in, not appointed, authorized back in 2020 as to electronic evidence. So I'm going to deny the motion for return of property based on the citations contained in the state's response. And I'll leave it up to you, Mr. Owens, to do what you need to do in order to have that review.
All right, I'm gonna do my best. We got about 18 days.
I'll cite to the parties for their own benefit. There were motions, specifically defendant's motion to appoint an electronic evidence expert and order the Justice Administrative Commission to pay costs. It was filed back on May 5, 2020. An amended motion was filed the next day, May 6th. Both of those cite to or refer to John Sawicki, S-A-W-I-C-K-I, electronic evidence expert. And there was a order entered back on August 3, 2020, appointing Mr. Sawicki as a forensic specialist. I have no idea if that order is still viable, but I'm just providing what the court file reflects in that regard. Lastly, that takes us to the notice of intent to rely on the defense of battered spouse syndrome. The original notice was filed September 6th. The state's original motion to strike was filed September 9.
Just to interrupt, I also have this defendant's motion for enlargement of time to address as well.
Yeah, I have that on my list, sir.
Okay.
Thank you. Thereafter, on the 15th, an amended notice of intent to rely on the defense of battered spouse syndrome was filed. On September 13th, the defense's response to the state's motion to strike defendant's notice of intent to rely on the defense of battered spouse syndrome was filed. And then I think it was this afternoon. Earlier today, the state's motion to strike defendant's amended notice of intent to rely on the defense of battered spouse syndrome was filed. The court has reviewed those and all of the citations contained therein. Mr. Owens, you may proceed, sir.
Judge, I wanted to start my argument, and then Mr. Henderson, who is on the screen, is going to respond to the state's pleading that they filed this afternoon.
Mr. J, you have any problem with that?
I know there's a rule in the circuit about one witness per one attorney. I don't know what the administrative rule says about arguments. I leave it to the discretion of the court.
Okay.
He's arguing that one motion that they filed this afternoon that I've been working on these. He was working on that motion, so it's a separate motion.
The motion to strike.
The last motion whatever motion they filed today, Mr. Henderson, Tony Henderson here in the screen wants to respond to that.
Okay.
I'm going to respond to the ones that were filed prior to today.
All right, I'll allow it. All right, go ahead, sir.
Judge, as you know, I filed my notice of appearance on August the 30th, I think 38 days prior to trial, knowing that the court had already made a ruling that you would not grant a continuance unless there was some type of exceptional circumstance. And Sarah Boone hiring or retaining or somebody pro bono coming on the case and representing her did not constitute exceptional circumstance. And so, as you know, we had the hearing after I'd filed the notice on August 30th. We had the hearing on September 3rd on my motion to continue. The court denied it. At that time, I explained to the court that I believed after my meetings, I think I'd had 4 with Ms. Boone, that she met the criteria for battered woman syndrome, but that I needed an expert. And we were vetting several experts at the time, 4 or 5 that we were vetting, and we needed more time to essentially pick somebody to go out and do an evaluation, an assessment of Ms. Boone to determine whether or not they would give an opinion that she suffered from that. Because, and I understand, the court denied our motion, so that left us with, we still had to give notice to the state attorney 30 days prior to trial of October 7, which I believe was going to be September 7, which fell on a weekend, which was that Saturday, I believe. So we got out of the hearing. I think the hearing was on a Tuesday. We had 4 or 5 days to file this notice, timely file the notice. So looking at the file, I realized that Dr. Harper had the most time with Sarah Boone. Early on in the case, I think when Mr. Padilla was handling the case, she was appointed by the court to do an assessment and evaluation. And so I reached out to her, and she agreed to come down a couple of days after we had that hearing, and she met with and assessed Ms. Boone. I've retrieved all the notes, the prior notes, and then the notes from that meeting. And then on Friday, I spoke with her, that Friday, which I believe was the date that I filed this notice, September the 6th. That Friday, I spoke with her on the phone and immediately went down and filed the notice of intent to rely on the defense of battered spouse syndrome. We made allegations that Dr. Harper had formed the opinion that at the time of this offense, that Sarah Boone was suffering from battered spouse syndrome. And at that time, we gave the name of Dr. Julie Harper and her address where she could be found and located. And of course, the state has set her deposition for October 1. Now, the state has filed a motion to strike the notice of intent, alleging that we didn't give sufficient facts or evidence. But Judge, realized at the time, I was simply trying to get it filed because the last day was the next day, Saturday. And of course, I had just gotten discovery. Judge Creighton, we have not finished reviewing all the discovery in this case. I pretty much shut my law practice down to try to do it. I've gotten my staff, and we're trying diligently to go through all the discovery. At the same time, we realize that we've got to establish corroboration of the battered spouse syndrome from eyewitnesses, from medical records, from potentially neighbors, court records, her phone and the information on phone. So we're diligently trying, number one, to review all the discovery, which still has not been done. At the same time, trying to locate additional evidence that we could utilize in helping to establish the battered spouse syndrome. In addition, the state attorney yesterday filed a notice that they're amending their discovery, and all the jail phone calls, or I think they have the ability not only to call, but they have a tablet and they can text back and forth with third parties, that they have disclosed that they have, I guess, 4.5 years worth of communications between Sarah Boone and parties on the outside, and that some of that may be relevant to the case. And we were advised that when I got in town that I was to bring a CD, and I did this morning. I went to the state attorney's office and spoke with the secretary and explained to her that here's my CD, I'll wait. And I was willing to wait in the lobby to get this additional discovery when we have 19 days for trial. She told me that there was quite a bit of it, that she would try to get it to me after the hearing or by the time of the hearing. I said, okay. I left the CD. I told her she had my number. She could text me. I was staying at the Hilton across the street from the courthouse. As soon as she had it, I wanted it as soon as possible. A short time later, they have started, I guess, going through that material, and now they're sending discovery through email. I assume instead of the CD, they're going to do it that way. But we are receiving it. But just the volume of discovery that we have to begin with, we haven't gone through. The evidence we're trying to gather to corroborate our defense, and then additional discovery that we were noticed about yesterday. I didn't have time. I knew this had to be filed. I had one more day. As soon as Dr. Harper told me on that Friday, I knew I had until Saturday. I filed it. The state knew. They've had it 4.5 years. They prosecuted the victim in this case, George Torres, at least 3 times. I think there's more like 4 or 5 times. But they opened up a file. They prosecuted him here in this county for battery in violating the conditions of bond relating to staying away from Sarah Boone, but battery on Sarah Boone. They, if anybody, was well aware that there was a potential problem with the habitual nature in which Mr. Torres beat on my client. In addition, my client expressed in the interrogation, which I know the court hasn't seen, please look at the videotape, please look at my phone, please look at the videotapes, please look at the photographs. I need my phone to show you. He comes at me. It was ignored. They've had all this evidence. They had to be on notice that this was a potential issue. And the reason being is all the lawyers that have been through this have appointed different forensic psychologists to assess her. The prosecutor that's not here today, that was here on September 3rd, when I mentioned the problems that we were going to have, getting an expert this quickly to form an opinion, said, oh no, Judge, we're not prejudiced. We've already got an expert. We intend to rebut any said opinion by an expert that she suffers from battered spouse. We're ready to go. We've got our expert. Such that they said, we don't even need a continuance. If in fact he finds somebody and they file something, a notice of intent to rely on battered woman syndrome within the time limits, we're ready to go. We don't need to continue it. We'll have our expert. And as you know, they're requesting that their expert now be allowed to go to the Orange County Jail and assess Ms. Boone, which they have every right to do, since we had filed this notice. But they indicated they would not be prejudiced. They indicated they were on notice. They didn't think it was going to happen 4.5 years, but it did. They knew all the prior abuse that Sarah Boone suffered at the hands of Mr. Torres. I did the best I could, Judge. I filed it. I felt like I had to have an expert. I explained in general terms that she was psychologically and physically abused by Mr. Torres repeatedly over a period of time that led to this event. They filed their objections, which we believe is misplaced. The court, as you know, by that rule, let me find it. It's apparent not only that the state was on notice, that we were going to rely on it, it was prepared to respond and was not prejudiced in any way. The notice of intent to rely on the defense of battered spouse syndrome comports with the requirements outlined in 3.201, given the current circumstances of the case. And as you know from that rule, it says the notice shall contain a statement of particulars showing the nature of the defense the defendant expects to prove and the names and addresses of the witnesses by whom the defendant expects to show battered spouse syndrome insofar as possible. Insofar as possible. I did the best I could, Judge. In addition, as soon as we started going through the discovery and gathering information about the prior events, the prior arrest of Mr. Torres, the prior prosecutions of Mr. Torres, we immediately amended the notice on September the 15th of intent to rely on the defense of battered spouse. And again, listed as many witnesses as we could based on the good faith belief that we had that corroborated either by witness testimony or physical evidence, photographs, videotapes, medical record, whatever we could find that would corroborate our defense. In addition, we've listed the ex-husband, Brian Boone, and the last paragraph, paragraph 14 says the defendant's investigation of evidence to support the defense of battered women syndrome is ongoing. The defense anticipates additional witnesses, photographs, videotape, medical records, court records, and other evidence gathered from the defendant's phone will be forthcoming. This evidence will be disclosed as it is discovered. Thank you.
Response, sir.
Judge, the state is not surprised by any of the evidence that has been in the discovery for years. I'm not going to belabor the facts in the discovery, but suffice it to say that the decedent and the defendant had a violent relationship, and generally this violence seems to be fueled by alcohol. We're completely aware of all of this domestic violence history, but that does not make a battered spouse syndrome defense any more than being mentally ill without showing more makes for an insanity defense. Their original notice was insufficient, and there's no reason to argue it since they've amended it. So turning to the amended notice, it still does not set forth what they are going to show that shows that she suffered from battered spouse syndrome. Was the decedent isolating her from her family and friends? Was he telling her that if she ever leaves him, he'll kill her? We have these instances of violence between the two of them. And when we get referred to the ex-husband, Brian Boone's deposition and statement, what he reports is that Sarah Boone would attack him, scratch him, punch him, and that she was a habitual alcoholic. And he would have to lay hands on her to restrain her. So we are going to potentially dive into all of this information in trial, but there are still the rules of evidence. And the cornerstone for the battered spouse syndrome defense, which is a misnomer under the case law, because self-defense is defense, and battered spouse syndrome evidence is relevant to help a jury understand why it's objectively reasonable for a battered spouse to stay in a situation that puts them in fear of continued violence. The state, and wherein our confusion lies, is nowhere in any of the witnesses or any of the discovery that they have listed, exhibits that they don't even have been listed, medical records and so on and so forth. Nowhere does it set forth this cornerstone that is absolutely necessary before we get into any of this battered spouse syndrome evidence, before we get into any potential reputation for violence evidence of the victim, before we get into any potential specific acts of violence by the victim, before we get into the rebuttal evidence that is going to be offered against her for her violent nature and her drinking. The cornerstone is self-defense. Her statement to the police is not one of self-defense. It is one of accident. She repeatedly says there was no violence that day. So that is where the state's position is, that their notice is deficient. It only sets forth that there has been violence between the two of them, and it's apparently exclusively alcohol related. But it doesn't go on to say this violence has caused her to suffer from the syndrome. And here's why. She was afraid to go meet with her family. She was afraid to leave. She was any of the things that make up what is actually battered spouse syndrome. And moreover, it doesn't set forth the self-defense claim, which is the cornerstone of this. None of this comes in without a claim of self-defense. And so that's in part why we filed our motion in limine with that response, is the court can and should not allow any mention of battered spouse syndrome come in until self-defense has been established at trial. And as far as I can tell, the only person that can set forth a self-defense claim, since it was just her and the decedent in the apartment that night, is her. So she'll need to testify, and then she'll be impeached unless there's a ruling that the statements that she made to the Orange County Sheriff's Office are not only a violation of Miranda, but are involuntary and unavailable for impeachment use. That's what we're hoping to avoid, because we can't unring the bell during trial. If they put on all this testimony and evidence about battered spouse syndrome and about the past violence, and then we introduce evidence about her past violence against him and against Mr. Boone, it's hard to unring that bell. And even though King versus State, a 2000, I forget which year, 19 case allows the state to point out the things that are promised in a defendant's opening statement, but then don't come to fruition, that doesn't unring the bell. So that's what we're asking for. We're asking for sufficient notice. The statement of particulars that is required by the rule, where is it setting forth there is a self-defense claim, and then there is going to be this shown beyond just the past violence between the two of them. Thank you.
Judge, they're scheduled to take the deposition of Dr. Harper October 1, so they're gonna know fairly quickly what her opinion is.
What's your response to Wagner?
We're going to talk about Wagner, Judge, and I don't want to talk about that in a minute, but he's bleeding the argument into state's motion to strike the defendant's amended notice. And I would like for Mr. Henderson to respond to what he said about that. But Judge.
I agree. There's two different issues here. The first issue is the sufficiency of the notice, and whether the notice is sufficient under the rule. The second issue from the court's perspective, is it applicable? And that's the hang up that I'm having.
That's not to be decided today. That's not Wagner, whether it's an accident or whether it's battered spouse and there was self-defense. That's not to be addressed today or not to be decided today. That's going to be based on the testimony from Ms. Boone about what was going on. But I'd like Mr. Henderson, if you don't,
but that's not what Wagner stands for. Wagner didn't allow, Wagner struck after multiple amendments, and the court, and we can take judicial notice of it if you want to, the court has pulled the file from the trial court in Wagner and has looked at the notices that were filed in that case for the battered spouse defense.
Judge, ultimately, the female defendant in that case claimed that the firearm discharged accidentally.
Correct.
And the court ruled, hey, you can't have it both ways. It can't be an accident and at the same time be intentional that you committed as self-defense because you're a battered spouse.
Right. So how is battered,
it's premature for them to be arguing the question of intent.
But that's not what Wagner says. What Wagner specifically says, although the trial court found the third legally sufficient, the court granted the state's motion to strike the notice and precluded appellant from presenting the battered spouse syndrome evidence at trial. And the DCA says that the evidence underlying in that case was all accident. Specifically, the located battered spouse syndrome as admissible where the defendant claims accident rather than self-defense.
We're not claiming accident.
Well, then what are you claiming?
Self-defense.
But every case that you cite, Medina, Hickman, its progeny, all pertain to some act by the accused. And that battered spouse is an excuse, a justification, an explanation for those actions. How is your purported defense applicable legally?
That's the reason we asked for the statement of particulars, Judge, so we could find out exactly what they were claiming that she did, what overt act or what omission. The overt act, was it zipping him into the suitcase? Was that the overt act that caused the death?
But all of the battered spouse syndrome cases talk about a defensive issue. Not meaning defense, your side of the ledger issue. I mean an action in defense. Wagner fired the gun. It was accidental. Hickman fired a gun. There was an act that was done by the victim or by the defendant in those cases. And battered spouse was used as an explanation for why it is that they did. How is that applicable to the case at bar?
I assume they're going to say she overtly zipped him up in the suitcase. I assume they're going to say he was asking to be let out of the suitcase and she refused. She failed in a duty to act. Later on, she went upstairs and fell asleep. So it's either an act or an omission, but they're claiming an act or a series of acts led to the death of Mr. Torres, which they have alleged was directly caused by Sarah Boone's actions or non-actions.
Hickman, the defendant, stabbed the victim to death. And the justification was battered spouse. In Terry, which you provided to the court, Terry v. State, 467 Southern 2nd, 761, it was firearm. What's the
mechanism?
What is it?
They're the only ones that can answer that, Judge. That's why we asked for the statement
I don't
of particulars.
understand that circular logic. And the reason I don't is because it's your defense.
Okay. I'm assuming that they're claiming that she zipped him up in the suitcase against his will, would not let him out of the suitcase, and therefore he suffocated. So the act of zipping him up and then the non-action of not letting him out when he asked to be let out constituted the offense of second-degree murder. That's the only explanation that we can come up with based on the report, based on the evidence we have. But Judge, you remember Marsha Thompson, the Palm Beach County case?
But there was a firearm.
There was a firearm.
She discharged a firearm.
Remember Dr. Brannon said on the issue of imminent threat, it is in the mind of the battered spouse woman.
Right there's the words. Imminent threat.
That's correct.
There was a threat. Now, I don't know all the cases. I don't know the facts and circumstances of that West Palm Beach case. I know snippets that you provided to me, but I haven't read any opinions on it. I don't know where it is on the DCA or appellate perspective, and trial court findings are not binding on another trial court. I mean, the case law is very, very clear on that.
Judge, the state doesn't know what happened the 2 minutes prior or the minutes leading up to, the time leading up to the 2-minute video. The state doesn't know what happened after the 2-minute video. Only Sarah Boone can testify to that. That's for her to testify to.
Florida, the appellant has not cited, nor is our research located, any Florida case holding that evidence of battered spouse syndrome is admissible where the defendant claims accident rather than self-defense.
Who claims accident?
Are you claiming self-defense?
Yes.
Well, that's the first time that I've heard that.
Judge, I just mentioned it a while ago.
The word self-defense never came out of your mouth.
Judge.
Words that you believe that the state's position is, what you believe that they're going to try to establish, that we don't know what happened before and after that video. The word self-defense have never been uttered this afternoon.
Judge, for the record, we're claiming self-defense. We're utilizing the battered spouse syndrome in conjunction with that defense.
Okay. All right.
Not accident, as they want to allege.
Okay. Does your compatriot want to provide response further? Okay. Mr. Henderson, good afternoon, sir. Can you hear us? If you can hear me, sir, you need to unmute yourself.
Can you hear me now, Judge?
I can, but I have some concerns because I'm getting reverb from you.
I am trying to talk you to now. Are you able to hear me better?
I am, but it's my that we're hearing back again through your microphone. All right, this may work. Mr. Henderson, we'll give this a shot, sir. You can go ahead.
Yes, sir. Can you hear me now?
I can, sir.
Is that better?
Yes, sir, it is.
Yes. Yes, Judge. I'd like to respond. And first, where I want to start is here. But just the self-defense, justifiable use of deadly force, justifiable use of non-deadly force. Those are defenses that do not require a notice at all. A defendant doesn't have to come in before trial and say that I am relying on self-defense. The standard is it's in the standard jury instructions, and before you can give that jury instruction, you have to have, and the cases are pretty clear, an indication or evidence. It's just a scintilla of evidence, is what the cases say, to get the instruction. There's no notice requirement in self-defense at all. Now, battered wife syndrome is not a defense in and of itself. There's no such thing as a defense there. It is a part of a jury instruction, and the part of the jury instruction of what it explains is when you get to the point when you're starting to talk about imminent danger, and that because of this syndrome, they will perceive an imminent danger different than someone else. Because what the self-defense instruction required is that the jury place themselves in the position of the defendant in those circumstances at that point. That spouse was to help explain those circumstances. So the first instruction that you have to get before you can even start talking about that spouse is this. You have to get the self-defense instruction. So, and that will be decided based on the evidence at trial. The defendant doesn't have to come in and say, I am claiming self-defense, this is self-defense, there's no rule or circumstance to that extent. But there has to be testimony of self-defense. Now, once there's testimony of the self-defense part of it, then the court can give that instruction. If they find it sufficient, the testimony can give that instruction as to self-defense. Where that spouse comes in and it goes into a series, you have to have self-defense or some type of evidence of abuse before you can get into the battered spouse. And this is how it should work. There could be the testimony of Ms. Miller. There could be testimony that's actually in the notice from officers who responded to calls and actually observed physical injuries on Ms. Miller. There could be testimony from others, neighbors, other people who observed injuries or certain things to Ms. Miller. But once you get to the point where you significantly or sufficiently apply that there is a battery or domestic violence situation that is ongoing, then, and not only, not before that point, can the expert come in and testify. So the stopgaps on this that are built into our system. First, there has to be some accountability or some evidence of self-defense. Secondly, there has to be some evidence that will support the expert's testimony to become relevant at that time. Once the expert's testimony becomes relevant, then the expert can testify about these are the symptoms that I observed, this is what I watched, this is where it came from, this was interviews, this was reviewing other type of data and other types of things and preparing their expert opinion. So after that point, Judge, when you get to that point, then it doesn't become a judicial act at that point in time. What it becomes a jury question. And it is up to the jury to decide. And what it does, and it doesn't say that battered spouse is a defense. What it will talk about in the jury instruction is this is something in the back and will report. Under these circumstances, if you find it credible, that you can consider. And that's what it does. So we at the beginning, when we start talking about motions to strike, because if I think the case was Wagner, there wasn't any testimony there. Wagner's testimony was accident, and I really put no one reviewed the ruling of that. That was the testimony. In this case, we do not have testimony. What we have is a say in this case saying the discovery in this case go get it. But that's not all. These rulings have to be made better on the testimony of the report, either testimony itself, physical evidence.
Mr. Henderson, we're having a difficult time understanding you, sir.
I'm sorry, Judge. Is that better?
Maybe. Madam Court Reporter and I were having a little bit of difficulty hearing you at the end. You seem to be projecting away from where your microphone is.
Okay. There's better. Can you hear me better now?
Madam Court Reporter. We will do our best, sir. Keep going.
Yeah. So to bring it in for a landing, Judge, is simply this. And to the court, here's the evidence that permitted at trial. The court cannot make certain decisions. The court can't make a decision if justifiable use of non-deadly or justifiable use of deadly force is appropriate to give and to the evidence at trial. At that point in time, the court has to make a decision if, after evidence, if the expert's testimony is even relevant. So if there isn't any testimony to prove the relevancy or to show the relevancy of the expert's testimony, then that expert can't come up and talk about that as fast. Now, if you don't get the expert to talk about battered spouse and render an expert opinion, battered spouse is out the window. So then you're just on self-defense at that time. But that argument and that decision can only be made after the evidence is put in that trial. And that's all I have, Judge. Thank you.
Mr. J, any response?
It sounds like we're largely on the same page. The one point that I would strongly disagree with is that this evidence of battered spouse syndrome is relevant to the subjective belief of the victim or the defendant. That is not what evidence is used for. It's used to help a jury understand what an objectively reasonable person would do in those circumstances. And there's more cases that I have not cited because I didn't know that would be raised today, but they kicked out PTSD testimony just last year, I believe it's in Okendo, because it was going to the subjective beliefs of the defendant rather than helping the jury understand why an objectively reasonable person in a battered spouse syndrome would stay. With that notwithstanding, it appears we're on the same page that the jury should not be hearing anything about battered spouse until the predicates are laid. And from the state's position to help us prepare for trial, pleading should be sufficient. And it's still our position that the pleading was insufficient. The state is well aware of the past violence between the two of them, with her being the aggressor and the decedent being the aggressor. There's evidence of that all throughout the discovery. But what isn't present anywhere in the discovery and what left the state at a lapse in understanding this defense in particular was, did this violence cause her to suffer from battered spouse syndrome? And what is this evidence going to be? Was he isolating her? Was he keeping her away from family and friends? Was he psychologically breaking her down? Was he doing any of these things that are a component of the battered spouse syndrome? Because all we have is her statements, which are almost 100 pages long, to the sheriff's office, where she repeatedly says that night that nobody laid hands on one another. It was a great night. We were hanging out, drinking wine, doing puzzles, painting, dancing with the dog. And then like everybody else, we were playing hide and seek, and he got into the suitcase and I accidentally went to sleep. And then she's shown her video, but her statements are all that it's an accident and that there was never any claim of violence that day between the two of them. So that's wherein the state's confusion lies. And I don't know how we're going to go about this at trial, if the defendant's going to have to testify in a narrative form, if she's going to come in and testify 100% differently than how she gave statements to law enforcement. But that's where we're at, is we don't want this in front of the jury until all of the requirements are met. And as far as I know, the only person that can say that it was a justifiable use of force that night is her, because it was only her and the decedent in the home that night. And thus far, she has not made any statements about a justifiable use of force. And then our second complaint about the intent to rely on the syndrome, again, without repeating myself, is it just sets forth that there was past violence between the two of them, but no particulars about what actually makes up the rest of the syndrome. Thank you.
Any other final positions offered in rebuttal to the state's argument, either Mr. Owens or Mr. Henderson?
Well, I'll let Mr. Henderson go, but just as it relates to Ms. Boone's testimony, that's what jury trials are for.
Mr. Henderson, any further arguments, sir? You're muted. You will have to unmute yourself. Mr. Henderson, you're still muted, sir.
I'm sorry. Can you hear me now?
Loud and clear, sir. Any other additional argument in rebuttal?
Yes, Judge. The state is going to have the opportunity to depose the expert, Ms. Harper, who can tie those things together. That's why we have experts who know about these things and who have the knowledge, who can tie these things together and tell why she's of the opinion that she was suffering from battered spouse at that time. The notice is simply to require to let them know that we're seeking this avenue and here are the witnesses that we're using to seek the avenue. We don't have to list a specific number of witnesses. It's just the ones that we intend to use. And as Mr. Owens has told you, this is an ongoing process and we'll probably be adding more. But that's all I have. Thank you.
All right. Thank you very much. The court is going to take the issue under advisement and provide a written order. I'll endeavor to do that by the end of the week. Last is the defendant's motion for enlargement of time filed September 17th. Mr. Jay, have you had the opportunity to review that?
Yes, Your Honor.
Okay, all right. Any problems with proceeding with that this afternoon?
No, Your Honor.
Okay, very good. All right, I have reviewed that motion. Mr. Owens, you may proceed, sir.
Judge, and I do have about 2 or 3 other issues that we need to address, but I've asked for some time. I think there was an order, I know there was an order that you had submitted to writing and that was filed with the clerk's file that indicated that you wanted some things from the defense and from the state by certain dates. And I think that's a typo on paragraph 3. I said August 17, that should be September 17 on paragraph 3, Judge, of my defendant's motion for enlargement of time.
That says September 5 on paragraph 3.
Are you looking at my defendant's motion for enlargement of time?
Yes, sir. Paragraph 3 says Dr. Julie Harper met with defendant Sarah Boone on Thursday, September 5, 2024. Am I looking at the wrong
Okay.
thing?
I'm sorry. I was looking at the wrong one. If you look at the second page,
Yes, sir.
paragraph 7,
Yes.
that should be September 17.
Yeah, got it.
Okay.
I mean, obviously the court's order, the August 5 order speaks for itself.
Judge, and as you know, we came in late. Dr. Harper formed an opinion that week. We filed a notice of intent to rely on battered spouse. It's ongoing. That's all I can say. We're working, we're doing everything we can to uncover evidence consistent with our defense. The problem is it's 4.5 years ago, and the apartment complex in Winter Park has changed hands. So we're trying to run down the employees. We're trying to run down the other tenants of the place. We're trying to run down medical records. That office manager is critical. We've taken her deposition, but we can't find her. Brandon, I think it's Moats, the neighbor that lived right next door to Miss Boone and Mr. Torres, and they shared a wall, is a critical witness in the case. We're trying to locate him. As you know, 4.5 years, people move. So we need more time, is my point. We're doing everything we can. We're working diligently. Billy Lane, the investigator, is working diligently to try to gather the information I'm asking him to gather. Coupled with the fact that we've got this phone that we're going to be extracting, I'm in hopes of in a few days. And I know that the state had extracted the phone and given us a lot of the data from the phone, but Ms. Boone says it's incomplete. That's the reason we want our own expert to extract it, that will be able to assist us in establishing evidence and testimony that she is a battered spouse and was a battered spouse prior to this event. But because of that, Judge, we haven't had time to complete that. And as I said in my motion for enlargement of time, we're asking to be flexible on some time limits up to and during the week of the trial, because we're going to be working that entire trial. Like I said, there's 18 days until trial starts. It's going to be a 2-week trial. I don't know when some of this information is going to come, but I assume every other day we'll probably be amending the discovery, the reciprocal discovery, and amending the notice of intent to rely on insanity or rely on battered spouse if we find other evidence that corroborates that. So we're just asking the court, and I know there's a rule that specifically this rule 3.050 that allows for this request. Thank you.
Thank you very much. State, any response?
Certainly the state is not going to be okay with them conducting their investigation once jeopardy has been attached. That is completely unfair to the state. This is the defendant's trial, not Mr. Owen's trial. She has been on notice of these charges since February 25th of 2020. She has gone through countless attorneys here who did not pursue this battered spouse syndrome defense, even though they had consulted with Dr. Harper back in 2020. And I believe the crux of that issue is going to revolve around her having to testify in the form of a narrative given her prior statements. So the state opposes any enlargement in time. The defendant has been on notice and has had centuries probably of legal expertise at her disposal for the last 4 years. And there may come a point in time where the state has to request a continuance prior to trial, but if this enlargement is granted. But certainly, once jeopardy is attached, that's not the time to be doing discovery. She's had 4 years to do this, 4.5. Thank you.
Any other final arguments, Mr. Owens?
No, sir.
Okay. I'm just rereading the rule. Give me a moment. Mr. Owens, as I stated when we had our hearing on September 3rd, at that point in time, the court had outlined the history of the case, the court's prior findings, the numerous experts that had been retained throughout this case, and I understand the position that you find yourselves in. But at the same token, based on the same analysis that the court had relied upon in its oral pronouncement in denying your continuance on September the 3rd, I'm going to grant your motion and deny your motion in part. With regard to the filing of objections to the state's exhibits, by your own statement, you're still in the process of going through those. The deadline expired on September 17th. So I believe that we're using the second portion of the rule with regard to that issue because there was a requirement to provide those names, and this motion was filed on the 17th. So I'm going to grant your motion in part with regard to filing objections for the state's exhibits. I will give you up until the time that we're having our trial case management on September 26th to file any additional objections to any of the state's exhibits. With regard, however, to the filing of a witness and exhibit list, I agree with the state. We can't be amending once jeopardy attaches to provide additional experts or any witnesses at that point in time.
You're talking about jeopardy when the jury is sworn?
Correct.
On that Monday, October 7th?
If we're lucky enough to get one on Monday.
So
just so that you understand, I've ordered a couple hundred people for that week because I don't know how long jury selection is going to take. I don't know what people know about this case.
Judge,
so my intention is to run 50 people in the morning. So I'm just letting y'all full disclosure here, what my thoughts are. 50 people in the morning. Get rid of language, get rid of cause. And if those persons who don't know anything about this case, I'm going to ask them to come back either Tuesday or Wednesday. And then we're going to run another 50 at 1:30. Get rid of our cause challenges, those who can't be here for 2 weeks, those who've just recently given birth, all the statutory cause reasons that they can't be here. I'm going to ask them to come back. And if we've got 40 people, 50 people at the end of Monday, we'll start Tuesday and we'll start whittling it down. And I can turn over when I'm done with my colloquy, my voir dire is about an hour and a half, 2 hours. And then I'll turn it over to the state and I'll turn it over to you and we can whittle it down from there. But if it takes us more time to get a sufficient panel because of the amount of time and other causes or preconceived notions about this case that can't be set aside, we may not be picking a final jury until Wednesday in this case.
Is this set for 2 or 3 weeks?
2 weeks. 2 weeks. Now, it was originally set for 3 weeks. And then when we talked about it, when you came on board, we had shrunk that to 2. Now, if we think that that may change, I'd rather discuss that now than a week from now. If you think we need 3 weeks, I can try my best to make that happen. But I respectfully need to know that sooner rather than later. Because in all candor, I don't know how long it's going to take.
I did not anticipate. I anticipated we were going to be able to pick a jury in one day.
I would love to be that bullish. I hope we can. I'd love to be able to. I'm just telling you what I've been working with jury services, that I've got 50 people teed up for 9 a.m. I got 50 people teed up for 1:30. And that will continue throughout the week. It's easier for me to say, we don't need you, go home, you don't need to show up for jury service, than it is, I need bodies and we don't have them. Now, if we're able to get a jury in one day, fabulous. But if we can't, I have that backup.
I believe if we pick the jury in one day, we could try the case in 2 weeks. But if it's going to take a little bit longer, and again, we don't know from now until October 7th what other evidence or what other witnesses we're going to uncover. So in the abundance of caution, I'm going to ask the court, if possible, to set 3 weeks. I don't think it's going to take 3 weeks, but I don't know how long jury selection is going to be. I don't know what additional evidence we're going to uncover, additional witnesses from now until October 7th. So to be on the safe side, I would ask for 3.
Okay. All right. I'll see what I can do there, and I'll have Anita report back to both of you.
Judge, and the main reason, I think all these other lawyers, they didn't have an expert that had tendered that opinion about her spouse. So we started on this path on that Friday when Dr. Harper called me and I filed the notice of intent to seek corroborative evidence, corroborative witnesses that she was battered. So that didn't really start until that day, which was September 6th. And that's why, and again, this was an event that occurred 4.5 years ago. Trying to locate witnesses, it's just taking time. I understand about the jury being sworn and we shouldn't be allowed to ask additional witnesses to come in. So I agree with the state on that. I agree with the court. But I would ask up until the time we pick the jury that we be allowed to amend reciprocal discovery and amend our notice of intent to add additional witnesses and additional evidence.
Mr. J, any other further positions, sir?
There just may come a point in time, Judge, if you don't set a deadline, that the state has to ask for continuance.
What do y'all think? Guilty?
All right, please be seated. All right, the court's been informed that the jury's reached a verdict. I say this in every case. One half of this room, I don't know which half, is going to be upset. Do not add injury to insult. If these people did not ask for this job, they didn't want the job, the state and the defense forced them into the job. You will not approve the jury's verdict, and you will not disapprove of the jury's verdict, or you will go to jail. It is a 30-day jail sentence for every outburst. I'm going to give anyone who does not believe that they are able to control their emotions the opportunity to leave the courtroom at this time. Would anybody like to leave? All right, Mr. Bailiff, please bring in the jury. You can sit right there, ma'am. I see you're holding some papers. The jury been able to reach a verdict in any of these counts. All right, if you would, please hand the paper to the bailiff. Ms. Gregg, please rise and come to the podium, along with your attorneys. All right, the verdicts appear to be in proper form. Verdict of the jury is count one. We, the jury, find the defendant, Carly Madison Gregg, guilty of first-degree murder as charged in the indictment. Count two. We, the jury, find the defendant, Carly Madison Gregg, guilty of attempted murder as charged in the indictment. Count three. We, the jury, find the defendant, Carly Madison Gregg, guilty of tampering with evidence as charged in the indictment. Please be seated, Ms. Gregg. Ladies and gentlemen, the jury is custom for the court to poll the jury. I have to do it each time. And for each count, I'm not being rude. The quickest way for me to get through this is to simply point at you and you answer out loud. As to count one, we, the jury, find the defendant, Carly Madison Gregg, guilty of first-degree murder as charged in the indictment. Beginning on the first row, ma'am, is that your verdict? Sir, is that your verdict? Yes, sir. Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? You got to answer out loud, ma'am. I'm sorry. Yes. On the back row, sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? That verdict is proper and unanimous. As to count two, we, the jury, find the defendant, Carly Madison Gregg, guilty of attempted murder as charged in the indictment. Beginning on the first row, ma'am, is that your verdict? Yes. Sir, is that your verdict? Yes, sir. Ma'am, is that your verdict? Sir, is that your verdict? Yes. Ma'am, is that your verdict? Yes. On the back row, sir, is that your verdict? Yes, ma'am, is that your verdict? Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Count three, we, the jury, find the defendant, Carly Madison Gregg, guilty of tampering with evidence as charged in the indictment. Beginning on the first row, ma'am, is that your verdict? Sir, is that your verdict? Yes, ma'am, is that your verdict? Sir, is that your verdict? Yes, ma'am, is that your verdict? On the back row, sir, is that your verdict? Yes, ma'am, is that your verdict? Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? All right, all three verdicts appear to be unanimous. The court will enroll the verdict. All All right, ladies and gentlemen, with you having returned a verdict of guilty in count 1 and count 2 of the indictment, we'll now proceed to the sentencing phase of the trial. State of Mississippi may call its first witness.
Your Honor, the state has no witnesses. We would just ask that the court adopt the previous testimony that the jurors have heard, with the exception of we seek to introduce one photograph.
All right. State wishes to move to adopt and incorporate by reference the record of the guilt phase. Is that correct?
That's correct.
Show your piece of evidence to the other side. Any objection?
Yes, Your Honor.
Y'all approach.
Sorry, had to make sure all my stuff was done. I'm surprised. I didn't know we were doing sentencing like good old Texas does sentencing. Interesting. And it sounds like they've maybe already stipulated to a lot. So I don't know that we're going to hear like too much.
So you just said they're sentencing her right now?
Yeah.
Oh, I love when they do this.
Yeah, because then we don't have to come back.
Yeah, you don't have to come back. I hate that. You wait like months.
Who'd have? I don't. It just takes you out back.
Oh man.
Sometimes people deserve it. Figuratively speaking, of course. You know. Is that her mom's relative sitting next to him because it looks like her mom?
Mm.
Oh goodness, I can't imagine.
Becca. Jesus. Oh.
All right, the state has moved to adopt and incorporate by reference the record of the guilt phase of the trial. The court will grant that request. Does the state have any other witnesses it wishes to call?
Yes, Your Honor.
All right, defense may call any witnesses.
We don't have any witnesses, Your Honor.
All right. With the defense not calling any witnesses, attorneys approach. Does the defense rest its case in chief as to sentencing? Do you also move to adopt and incorporate by reference the record? All right, y'all approach.
One last approach. Yeah, that's kind of crazy that no one has anything to say. I wonder if we'll hear from her. Yeah, Grandma, you came in hard. Grandma will take her out back. Who'd have?
Grandma doesn't mess around.
No. Consequences, little girl. Go to your room forever. Don't ever come back.
I mean, she only called me a heathen, and I only missed one Bible trivia. My goodness.
All right, ladies and gentlemen of the jury, with both sides agreeing to rely on the testimony from the guilt phase, the court will further instruct you at this time. You, the jury, have found the defendant guilty of the crime of first-degree murder in count 1. You must now decide whether to impose either a sentence of life imprisonment in the custody of the Department of Corrections or life imprisonment in the custody of the Department of Corrections with the possibility of parole. The court instructs the jury that you should consider the following factors in making your decision. 1, the defendant's chronological age. 2, the defendant's family, home, and environment. 3, the circumstances of the homicide offense. 4, the defendant's incompetencies associated with youth. And 5, the defendant's possibility of rehabilitation. The court instructs the jury that when all 12 of you reach and agree upon the defendant's sentence for first-degree murder, you shall return the sentence in one of the following forms. If you agree to sentence the defendant to life imprisonment in the custody of the Department of Corrections, your verdict will be as follows. Quote, count 1. Quote, as to count 1, we, the jury, sentence the defendant, Carly Gregg, to life imprisonment. Close quotes. If you agree to sentence the defendant to life imprisonment in the custody of the Department of Corrections with the possibility of parole, your verdict will read as follows, quote, as to count one, we, the jury, sentence the defendant, Carly Madison Gregg, to life imprisonment with the possibility of parole, close quote. If you cannot agree to the sentence for the defendant as to first-degree murder, your verdict will be as follows, quote, as to count one, we, the jury, are unable to affix the punishment, close quote. You, the jury, have found the defendant guilty of the crime of attempted murder in count two. You must now decide whether to impose either a sentence of life imprisonment in the custody of the Department of Corrections or life imprisonment in the custody of the Department of Corrections with the possibility of parole. The court instructs the jury that you should consider the following factors in making your decision. 1, the defendant's chronological age. 2, the defendant's family and home environment. 3, the circumstances of the homicide offense. 4, the defendant's incompetencies associated with youth. And 5, the defendant's possibility of rehabilitation. The court instructs the jury that when all 12 of you reach and agree upon the defendant's sentence for attempted murder, you shall return the sentence in one of the following forms. If you agree to sentence the defendant to life imprisonment in the custody of the Department of Corrections, quote, as to count two, we, the jury, sentence the defendant, Carly Madison Gregg, to life imprisonment, close quote. If you agree to sentence the defendant to life imprisonment in the custody of the Department of Corrections with the possibility of parole, your verdict will read as follows, quote, as to count two, we, the jury, sentence the defendant, Carly Madison Gregg, to life imprisonment with the possibility of parole, close quote. If you cannot agree to the sentence for the defendant as to attempted murder, your verdict will read as follows, quote, as to count two, we, the jury, are unable to affix the punishment, close quotes. All right. First closing by the state as to sentencing. Mr. Bailiff, 7.5 minutes. You wish a 2-minute warning or a 1-minute warning?
1 minute is fine.
1 minute. You may proceed.
Ladies and gentlemen, you've been here for 5 days now. Over 5 days, we've heard about this terrible crime that was committed by Carly Gregg. You have to consider her chronological age. We can't change that. She's 15 years old. In the eyes of the law, we talked about this on Monday, Carly Gregg is an adult. You do get to consider her age, but that's not the only factor you consider when you determine whether or not to send her to prison for life. We'd ask that she be sent to prison for life without the possibility of parole, and let me tell you why. When you consider her family and home environment, ladies and gentlemen, by all accounts, the defendant has told you she had a loving home. She had parents that adored her. She had every opportunity, more opportunities than most kids. She was advanced in school. She had guitar lessons. They took her to equestrian therapy. They took her to counseling. She had the opportunity to have medication. Nothing was enough for her. She still committed these heinous crimes. Nothing. Her home life was a perfect home life. When we talk about these factors in Miller, that usually comes up when we talk about these defendants that have been grown up on the streets when their parents weren't present. Now, did Carly have a dad that she didn't love or had problems? Absolutely. But ladies and gentlemen, that is not enough. That is not enough for her to be able to walk the streets. She murdered someone. She attempted to murder her stepdad. Her family life and her dad being on drugs is not enough. The circumstances of the homicide, I don't have to tell you that. Y'all just lived it. You watched it. You saw those awful photographs. You had to watch that terrible video. We listened to Ashley Smiley's last sounds. We heard from Heath Smiley on that 911 call, the desperation. He said, help me, help me. Ladies and gentlemen, those crimes were awful. She has shown zero remorse for what she has done. Let's talk about her ability for rehabilitation. The defendant's own expert during the guilt phase of this trial said, you know, she's on this medicine, she's fine. But if you believed that, ladies and gentlemen, you would have believed that she was having some disassociated spell at the time of the crime and that she's continuing to have these disassociated spells. And obviously no one's buying that, right? We don't know why she committed these crimes, but we know she did. And we know that she is a danger to society. If she is given the possibility of parole, no one in this room knows how long she will stay there. We cannot guarantee she will stay there 1 year or 10 years. We have no control over that. Ladies and gentlemen, we watched one of the most heinous things that I believe most of you will ever see in your life. Please do not let this lady have the possibility of parole. If she were paroled, nothing would stop her from walking into a school. Nothing would stop her from walking into a shopping mall. Nothing would stop her from walking into the grocery stores. Nothing would stop her from being in the movie theaters. Ladies and gentlemen, she is dangerous. She may look like a little girl. They may have said she's sweet little Carly, but unfortunately, we all know that that's not true. We will ask, and I will ask you again when we stand back before you, that you sentence Ms. Gregg to life in prison without the possibility of parole for both the murder of her mother, Ashley Smiley, and the attempted murder of her stepfather, Heath Smiley. Thank you.
Argument says sentencing by the defense. How much of a warning would you like, Mr. Camp? 2 minutes. 15 minutes total.
Thank you, Your Honor.
Yes, sir.
I'm gonna have to tell you, this is probably the most difficult thing I've ever had to do. I respect your jurors, and I respect your verdict, and I totally understand that. And now I'm in front of you. Carly Gregg, when this happened, was 14. She's 15 now. Her family's sitting on the front row. Her grandparents, which are Ashley's mother and father, have been supportive during this whole process. He's smiling. Who's the victim in this case? He has been supportive. This is a family that's been torn apart because of this. This is extremely, extremely difficult on all them. And I know the state is up here saying that she's this heinous individual. And you've heard a lot of testimony that that's not who Carly is. You heard the counselors, Ms. Kirk. She couldn't believe it happened. Nobody knows why it happened. You have the opportunity to not make this worse on the family. You have 3 options. You can do life without parole, you can do life with parole, or you can let the judge make the determination. In this case, we would ask you, let the judge make the determination. We don't want you to give her a sentence for life in prison. Life in prison is life in prison. That's it. 14-year-old. She can come out of this at some point. And you were hearing she can walk out of here in 10. We don't, first of all, we don't know. Usually it's a lot longer than that. I mean, a lot longer. So, I don't want you to, go back in that room and think, oh, if you come back and say she gets parole, it's not a short sentence at all. We would ask you to allow the judge to make the sentence, because the judge understands. I'm not saying y'all don't. I mean, you don't have the ability, so don't get me wrong on that. But he knows, and the court knows, what we're actually looking at with times. And so please, in this situation, please let the judge make the sentence in this case.
Final closing on behalf of the state.
Ladies and gentlemen, Mr. Camp is right. We may never know the reason why Carly killed her mom and attempted to kill her stepdad. And for me, that's even scarier than knowing why. Because if we don't know why, what's to say it won't happen again? We don't know. It is terrible for the family. The family has my sympathies, absolutely. I cannot imagine what any of them have gone through. We talked in voir dire about how sometimes the victims cooperate with the prosecutor and the prosecution, and sometimes they don't. We don't always know why. But I know this. My office represents the citizens of Rankin County, and my office is asking you to please sentence Ms. Gregg to life in prison without the possibility of parole. Thank you.
Ladies and gentlemen, the jury, you've received you've heard the arguments. I'm going to ask you, I'll send you back the instructions. I'm going to ask that you retire to begin your deliberations. Everyone remain seated while the jury exits. Bailiff, they still have the verdicts, the evidence? Yes, sir. All right, if you would take those to them. All right, we'll be in recess till such time as the jury reaches its verdict regarding sentencing.
I think they'll give her the possibility of parole too. I don't know what the, sorry, I'm not supposed to have her face on camera, so I'm trying to keep it off of there, but get close enough to my mic. I don't know what that minimum sentence is. And maybe the judge will know it better. That's why the defense asked them to let the judge do it. But it'll be interesting. I wonder how long that will take. I was kind of shocked that they didn't have them test or speak, do something. Teresa says she better finish her Coke. Bail pending appeal. I doubt it. She's on $1 million bond. Like, she's held on $1 million. Yeah, all that commissary is pricey. So I don't know how long it'll take for the sentencing. I bet it doesn't take very long. They probably already have maybe an idea. Yep. Well, Diddy did some things. He's also on video doing things he shouldn't have done. There's cameras everywhere. All right, we can we got a little bit left of the Sarah Boone. And here comes Super Sun. Yes. Diddly the diddler. Oh. Here they come. Diddy the diddle. The didder. Is that like